Lots.
Let's.
There is no alternate entry. Right. Yes.
Come next week, but they can't wait till next week. Any urgency that?
My lords, this is education. Yes.
So, my lords, it's a bail matter, my lords, yeah. The lordship has ordered to be listed on 12th, my lords. It was not listed. 2 times I have moved the memo, my lords.
Yeah.
Bail.
No.
My lords, this is education matter. My lords, urgency is, my lords, tomorrow is the last date
Right.
for compulsory service, uploading of and the registration, and day after onwards, the counseling and allotment starts. My lords, if they do not attend, 25 lakhs penalty is going to be imposed on them. Therefore, my lords, it may be heard tomorrow.
No, but now what we can hear?
My lords,
Now how we, old matter, fresh matter?
fresh matter,
Well, you serve on the
state,
answering respondents.
state, yes, my lords.
My lords, tax matter, my lords, it's covered by your lordship's judgment. Matter pertains where a work contract is, tax has been imposed by the.
Correct, but it can come next week.
My
What
lords,
is it?
I have already moved last week, my lords, date was given today, the matter has not been listed. The urgency is that 27, they are fixed for a personal hearing. The commissioner may pass an order for recovery, my lords.
Tomorrow you take a chance. Tomorrow,
Please, my lords.
that's it.
Your lordship, this is a tax matter. The petitioner is challenging the order to pay taxes on.
So it can come next week. What is all other matters of royalty also there is a stay. They won't take any action. Let it come next week.
Next.
Yes.
Transfer office. Transfer office. ಇಲ್ಲಿ ಬರಲ್ಲ. ಇಲ್ಲಿ ಬರಲ್ಲ.
City.
Income tax matter. Demand of recovery corrected. There, madam. Tomorrow it's not.
My lord, we are filing memo for posting in education matter, my lord. The similar matter is pending before this court, my lord. That is the grace marks related issue regarding the MBBS students, my lord. There is an urgency regarding because next month there will be the exam, my lord.
No, that I've heard and reserved it. I've heard and reserved that batch.
But this is the similar, this is a fresh matter, my lord.
Correct. Now we can't tag it with that. So whatever you keep your eye out on what will come, that will inure to your benefit also.
Adjournments, list 1, page number 1, serial number 1 to 5. Page number 2, serial number 6 to 12. Page number 3, 13 to 17. Page number 4, 18 to 20. Page number 5, 21 and 22. Page number 6, 23 to 25.
My lord, serial number 43, my lord, I may permitted to withdraw the writ petition, my lord.
Yes. In light of the memo filed, the petition is dismissed. Memo for withdrawal reads as under. Yes.
Please, ma'am.
Page number 7, serial number 26 to 32. Page number 8, 33 to 39.
My lord, serial number 33. I pray for 2 weeks time, my lord. Readings has to be complete.
Inform the other side.
I have already.
Lordship, 1 week kindly, your lordship.
It may not be possible.
Next
Complete with
week.
readings.
Let us see if his client gets back earlier, you find out, let it come earlier.
Please.
List after 2 weeks.
Yes.
Page number 9, 40 to 47. Page number 10, 48 to 53. Page number 11, 54 to 58. Page number 12, 59 to 65. Page number 13, 66 to 70. Page number 14, 71 to 73. Page number 15, 74 and 75. Page number 16, 76. Page number 17, 77. Page number 28, 78. List
With your
1.
lordship's permission, I make one submission. This GST matter was supposed to be listed today, but it's not on the cause list, your lordship. If it may be taken up at 2:30.
Tomorrow. You take a chance tomorrow.
And your lordship, there were 2 other matters, though I'd made a mention, I apologize. You had made a mention and the memo was accepted.
But those two matters are also not listed, Your Lordship.
That you take a chance next week.
There's an urgency because the orders have been passed. One is in respect of service tax,
fresh
fresh matters.
Okay, give it.
Next one, fresh matter, serial number 1. Rajesh, sir.
Lord, the order said, my lord, the 10%, 16.4 issue, deposit of 10%. Petitioner claims that they've deposited it, and further, my lord, we've still attached. There, we've looked at the portal. There is no payment that has been made.
No, Your Lordship, it is made, but it's not getting downloaded. I'll
It's
check
not-
and come back to Lordship.
Not reflected in the GST portal.
That you bring it to the notice.
Yes,
Oh.
Your Lordship. I'll submit that documents.
So they will verify. If it is so, they will take appropriate action. I'll have it next week.
Yes, my lord.
Now you clarify
Yes.
Yes.
I'll.
the matter next week.
Great.
Serial number 2.
To consider my representation, email.
Yes, M. Kumar.
It's, the representation, my lords, will have to be given to respondent number 1, my lords. Because other respondents, my lords, will not be competent to decide on the representation. If they make a composite representation before respondent number 1, some time-bound directions of 3 months may be issued to dispose of after hearing them.
First respondent. Let them consider.
So the same what they have given to the others. Composite representation may be made
Copies of those representation along with the covering letter may be given to
first.
first respondent, who will be competent to consider it.
We'll dispose it off.
Please.
The petitioner has sought for issuance of writ of mandamus to direct respondent number 1 to consider and dispose of the representations at annexure E1 to E7 and the representations at G series. Certain consequential reliefs upon consideration of representations, if made in the affirmative, are also sought. The representations made at E series have been addressed to respondents 2 to
8, madam.
2 to 8. And by virtue of such respondents, the petitioner has requested the authorities that GST component was not a part of the contractual agreement. And accordingly, has sought for making reimbursement of GST paid by the petitioner from his own funds. Full stop. Learned Counsel M. Kumar, appearing for the state, submits that though the representations are addressed to respondents 2 to 8, it is the first respondent which is the authority competent to take a decision as regards the subject matter of the representations at annexure E series and G series. Full stop. In light of the same, it would be appropriate to dispose of the writ petition with the following directions. Petitioner to make out a composite and comprehensive representation to the first respondent containing the grievance as made out in the representations at annexure E1, at annexure E series and G series. If such a representation is made to the first respondent within 10 days from date of disposal of the petition, the first respondent would thereafter be directed to consider such representation and dispose of the same after hearing the petitioner. Accordingly, petition is disposed of. All contentions are kept open. State to consider and pass orders within a period of
3 months, my lords.
12 weeks.
Please.
12 weeks from date of submission of representation to the first respondent.
Serial number 3, Balachandran.
My lord, appearing for the petition. This is an income tax matter. The challenge is to annexure H, which is the assessment order,
Yes,
and also to annexure G, which is the.
income tax.
My lord, I'm given to understand that Mr. Tirumalish. The
We are online.
Yes, yes. Learned Counsel Shri Tirumala is directed to accept notice for respondents 1 to 4.
My
You
lord, there is a-
survey copy on it, we'll have it next week.
well,
let him
my
have a
lord,
look
there
at
is a bank attachment, so that's the only urgency.
But let him have a look at it.
Very well.
Consideration of interim prayer is kept open. List the matter next week.
Serial number 4.
Yes.
Appear for the petition. Lords, they've challenged the assessment order and penalty
Yes,
orders.
yes.
My lords, it's an ex parte order. They've not appeared, my lords, before the assessing officer. My lords, annexure C, my lords, page 22 is the assessment order. My lords, page 23, my lords. My lords, they have not responded to any of the notices, my lords.
Yes. Yes,
Lordship may kindly consider to remand it to the stage of show cause notice, let them file a reply.
yes. What is the reason for
What has happened, my lords? My husband was, my lords, doing the business. He was not keeping well, my lords. So on that particular time, my lords, the transaction was made through my account because, my lords, to go to the bank and all these purposes. I'm a housewife, basically. That is how, my lords.
any of husband you are responsible?
Certainly, my lords. That's one opportunity, my lords.
Yes, the petitioner has filed the present writ petition seeking for issuance of a writ in the nature of certiorari to set aside the penalty order, to set aside the assessment order, demand notice and penalty order. Full stop. Petitioners also sought for setting aside of the demand notice and show cause notice under section 271 AAC within bracket 1 and 272 capital A 1D. It is the case of the petitioner that the petitioner was unable to participate in the proceedings due to the ill health of the petitioner's husband during the concerned assessment year. Full stop. It is further submitted that the accounts and business was looked after by the petitioner's husband. And in light of his ill health, petitioner was not in a position to respond to the show cause notice. Full stop. Peruse the order. A perusal of para 2 of the order at this is penalty order A.
My lords, penalty is the first order, please, my lords. They should have challenged the assessment order first.
That is Annexure C.
Annexure C, my lords, page 22 is the assessment order.
A perusal of the assessment order at Annexure C would reveal that perusal of the assessment order at Annexure C in para 2 would reveal that the petitioner has not participated in the proceedings. Full stop. It is noticed that by virtue of non-participation of the petitioner, assessment is complete concluded on the basis of best judgment assessment.
Please.
Full stop. By virtue of such proceedings, the assessing authority has observed that in the absence of return of income, as well as any explanation / clarification of cash deposit to the extent of 1 crore.
1 crore 33 lakhs.
1 crore 33 lakhs 97,700. The said amount has been treated as income chargeable to tax that has escaped assessment or remained unexplained. Full stop. The in light of full stop, in light of the same, as counsel for the petitioner submits that if an opportunity is afforded, they would explain the source of such deposit. It would be appropriate to afford an opportunity for the petitioner to participate in the proceedings. Full stop. Next, this would also result in the actual income that is escaped to tax to be determined on the basis of the reply to be made out by the petitioner. In light of the same, the orders at Annexure A to C and E to G1.
Please. E, my lords,
E
at page 41.
are required to be are set aside and matters remanded to the stage of reply to show cause notice. All contentions are kept open.
Public.
5, Sanmati. Shaman Naik.
On the last occasion, I sought for
IF
that is medical
dispensation.
record, Milord. The petitioner was not able to appear before the nothing authority, Milord. Could not release the books of account.
ಯಾವ ಡೇಟ್?
122. That's for me. Your Lordship, it is dated second page, Milord. The doctor has certified that from 1/3/2024, Milord.
But what is it, sir? What is certified by the doctor? Doctor only knows.
Yeah, real doctors have it.
So at least what is written?
Your Lordship, this is to certify that Mr. Prakash Chand, son of Uttam Chand, is
Suffering from?
is suffering from ugly cure. I am advised to him not to for 2 months.
Is that some Alzheimer's or what? Huh?
And in the next page, Milord, he has advised some prescription also, some tablets also it has been.
In Sikiri.
Yes. Yes. Yes.
Clear a copy, my lord, of the medical certificate. will give us reasons at least what it is.
Your
Not
Lordship,
able to make out the ailment to say.
Your Lordship, this was also brought to the notice of the assessing authority, my lord, because of health reasons he could not appear, my lord.
Page,
Your Lordship, page number 20, my lord. Your Lordship, at page number 15, my lord. At conclusion of the officer, my lord. Your Lordship, the TPS questioned that matching mechanism of ITC has been kept in abeyance. First of all, the TP has not responded to the ADT 01 or reminders issued by the department calling for books of account and has failed to produce any books of account as required for auditing. Expecting the AO to do matching without production of books of account is not justifiable on the part of the TP. Your Lordship may kindly see, my lords, when the audit proceedings took place, my lord, he had contested and he had also produced the books of account. The reply is, my lord, at page number. The reply filed by 29, my lord. This is the reply filed before the audit authorities, my lord, for the assessment year April 2018 to March 2019, annexure C, my lord. Your Lordship may kindly see in this reply, my lord, he had produced several documents. At page number 33, your Lordship can see, my lord. Purchase register as annexure A1 and supply and the inward supply recorded in books of account is A2, my lord. And in the next page, my lord, at page number 34, my lord, annexure A3, my lord, for the extract of the ledger statements of the supplier, my lord, annexure A3 and several other documents, my lord, have been produced, but the books of accounts were not produced, my lord. And before this honorable court to prima facie prove that I am able to produce some documents, my lord, I have filed with memo, my lord, additional documents.
yes,
Audit report, income tax return, balance sheet, profit and loss account, and certification and GSTR returns, sales report, ITC credit, reconciliation statements, and further documents will also be produced, my lord, if the matter is demanded, my lord.
yes.
A particular date may be fixed so that I can produce and appear and produce the documents and also replay.
The petitioner.
Cost be imposing.
The petitioner has sought for setting aside of the summary of the order under section 73(9) at annexure A, as well as summary of the. Now, what is A and A1? Has sought for setting aside summary of the order under section 73(9) at annexure A. What is A1?
Summary order is A1, my lord. Detailed order is, my lord.
A is the annexure A is the detailed order. Summary.
Summary of, but it says summary of the order.
Summary of the order is the main order, my lord.
That's the main
The
order.
main order.
Is challenge the assessment order at annexure A, as well as the summary of the order at annexure A1, by virtue of which the assessing officer has confirmed the tax liability and interest and penalty as proposed in DRC 01 and has issued DRC 07 crystallizing the liability. It is the case of the petitioner that during the relevant period of time, he was not keeping well, and that he is in a position to make out his case as against the show cause notice by producing necessary documents, which if taken on record, conclusion had arrived at by the authority would stand modified. Demonstrate such bona fides The counsel for petitioner has filed a memo along with the list of documents including audit report under section 44 AB of Income Tax Act, the balance sheet for the relevant period, as also the profit and loss account, and further produced Form GSTR 3B, Form GSTR 9, and Form GSTR 9C, along with Part B certification. Full stop. Petitioner has also produced the sales report and ITC report along with the memo. Further submitted that documents produced are only indicative, and petitioner, if provided an opportunity, would produce further documents to clarify the show cause notice. Full stop. The petitioner has also filed, along with the memo, the medical certificate and submits that during the relevant period of time, the petitioner was not keeping well and was under treatment, and that explains his absence in responding to the proceedings before the assessing officer. Full stop. Perused, full stop. Next. Even mail hacking. Counsel for petitioner further submits that during the audit proceedings, a number of records have already been produced by him, and draws attention to his reply at Annexure C, wherein reliance is placed on documents produced at Annexure A1 as well as A2, wherein reconciliation is sought to be made out.
Yes, my lord.
Full stop. Next. Peruse the order at Annexure A. The assessing officer has observed that the taxpayer has not responded to the reminders or any of the notices. Full stop. In light of no absence of reply, the assessing authority has concluded that the taxpayer not having responded to ADT-01 or reminders issued by the department calling for books of accounts, and having failed to produce any books of accounts as required, the assessing officer is not expected to do matching without production of books of accounts. In light of the same, conclusion is arrived at by confirming the tax liability, interest and penalty as proposed under DRC 01. Full stop. There is an observation made in the assessment order that though time was granted in light of health reasons made out, however, despite further opportunity granted, there was no response from the petitioner. Next. Taking note of the petitioner's reply during the process of audit at Annexure C, and noticing annexures produced in such reply at Annexure A1 and A2.
Yes, my lord.
Which are
And also other annexures, my lord.
and other documents which would indicate that the petitioner has sought to make out a reconciliation and also matching, and noticing that the petitioner's reason for absence is due to medical reasons, as indicated from the document produced along with memo before this court. it would be appropriate to afford an opportunity to the petitioner. Full stop. Accordingly, order at annexure A1 are set aside, matters remitted to the stage of reply to show cause notice. Full stop. However, noticing that there has been admitted lapse on the part of the petitioner, which the court has condoned by taking note of the lapse in a lenient manner. Petitioner to pay nominal costs of how much? 10,000.
The other matter was 10,000.
Huh?
Similar matter, 10,000.
10,000 to
The
respondent, which to the respondent.
Date be fixed also, my lord. Date be fixed for him to appear before the
The
Fifth
petitioner
August
to,
in other matter. it has been
petitioner to appear before,
5th August, in other matter it is on 5th.
to appear before the respondent on 5th of August.
Yes.
Accordingly, petition is disposed of. Next time you have to get typed prescription from the doctor. Yes.
6, sir. Till number 6.
Yes.
May it please your lordships.
Yes.
May it please your lordships.
Highly detailed counter, my lordship. Challenge is only to show cause notice. The participant. Challenge is only to show cause notice pursuant to certain observations in the Delhi High Court judgment. File a detailed counter, my lord. I have yet to receive instructions. But the
Lordships,
methodology adopted is found to be, as Delhi High Court has observed, that the methodology adopted to passing on of the input credit to the consumers, in the real estate sector, whatever is followed by the respondents was treated to be flawed ones. So that is why it has to be redone. So pursuant to that, the notices have been issued. The only thing, challenge is only to show cause notice.
Lord Counsel for the Revenue seeks for
Lordship, may I
time.
just submit, my lords? My apology, my lords.
Now, what is the interim relief you're seeking now?
My lords, the interim relief is that they should not reinvestigate. This is not a show cause notice, my lords. Kindly have a look at this, my lords. They had undertaken an investigation. The DGP had filed a report. There is an order passed by the National Anti-Profiteering Authority. That order has been implemented. There is no challenge to that order. And in my respectful submission, Delhi High Court has not issued any such instructions that they are construing, my lords. The Delhi High Court matter is still pending. Lordship, may kindly see the Delhi High Court observation at para 127. Kindly have that, my lords. It's totally incorrect submission, my lords. They want to reinvestigate a closed matter, a matter which is concluded,
Page?
closed.
Page?
Lordship, may kindly see.
Judgment is here.
Lordship, in this Delhi, before the Delhi High Court, my lords, I'll just give a background. The challenge to the validity of section 171 and the rules made in the statute were challenged.
You are
That
part of the.
challenge has
you are
been
part-
repelled.
You are part of the batch.
No, that's the part, my lords. I am not part of the batch. I am not concerned with that. I am nobody. Nobody has given this direction. I am not a party to the Delhi High Court petition. Those were challenged by some petitioners before the Delhi High Court, challenging the validity of the section and the validity of the rules. That challenge has been negated. If your lordships kindly have page 1 to para 127 of that judgment, the matter is still pending before the High Court.
Yes.
Lordship, may kindly have just have para 127 of the judgment, my lords.
Yes.
Your lordships have para 127.
Yes.
Lordships, since considerable emphasis was laid down by the learned counsel for the petitioner on the methodology adopted by the National Anti-Profiteering Authority to determine the commensurate reduction qua the real estate industry, this court deems it appropriate to deal with the same at some length. With the introduction of goods and service tax regime, the availability of input tax credit against various goods and services used in the construction has increased the input tax credit available against more goods or services than before. This resulted in decrease in the cost of the builders as they now have more input tax credit available to be set off against goods and service tax paid by them. in the goods and service tax regime as compared to before. And the same was not required to be collected from the consumers. There is no dispute with regard to the methodology to be adopted in the following 4 scenarios. If the flat was completely constructed in the pre-GST regime, that is before 1st July, and if it was purchased by making
Now, let us see, just 1 minute. Now you are saying that
My apology.
already the inquiry was concluded.
Yes,
as
my
against
lords, inquiry has been concluded, order has
Where?
been passed.
Annexure?
Lordship may kindly see the report at annexure at page 43, my lords. At page 43, your lordships have that, my lord?
Annexure B.
Annexure B, my lords, my apology, annexure B, my lords.
That is the report.
That is a report dated 3rd of April 2019.
What is the conclusion?
There they have followed the procedure. These documents were asked, and lordships may kindly see paragraph page 46. Their investigation and finding. Detailed report has been prepared, my lords, starting from paragraph page 46 till
No,
page
what-
51. Kindly see the conclusion, my lords. Conclusion at para 23.
Yes.
Your lordships have that?
Yes.
Lordships para 23. From the above discussion, it is found that the benefit of additional input tax rate of 2.5% of the total amount demanded by the noticee from the applicant and the other home buyers who made the bookings before 31st of August 2018 accrued to the noticee, and the same was required to be passed on to the applicant and other recipients. However, as can be seen from para 17 and 18 above, as well as table C and D above, whereas the noticee was required to pass on the benefit of input tax credit to the tune of 16 crores, they have actually passed on the amount of rupees 22 crores,
Yes.
thereby passing an extra amount of 5.59 crores. This extra benefit passed on by the noticee to the home buyer can be adjusted against the demand raised on such
Now
home buyer.
what is sought to be, this is sought to be reopened by?
Reopened
By?
by page 80. Page 80, my lords. That is, my lords, April 2024. Lordships have that, my lord?
Yes.
Consequent to Honorable Delhi High Court dated 29th of January 2024, the Competition Commission
Let
of
us see, you file your objection. Will appear the petitioner that by virtue of the report at Annexure B by the Director General of Anti-Profiteering, within bracket, Central Board of Indirect Taxes and Customs, close bracket, the finding recorded is to the effect that the petitioner has not violated provisions of 171(1) of the CGST Act 2017. That's the conclusion. What is the conclusion? That you are
Lordship,
not
that's the
violating-
conclusion. Yes, my lords.
Full stop.
Para 24.
And
that's the
despite
conclusion.
such report made out on 3rd April 2019, the very same subject matter of such report is sought to be reopened by way of notice at Annexure D.
D, my lords.
Annexure D.
D.
There will be an interim order of stay of further proceedings. Stay of Annexure D and proceedings pursuant thereto. Full stop. Learned counsel appearing for respondent number?
B.S. Venkatnarayan.
For respondent number?
All respondents.
For the respondents, Shri so and so, request for time to file a detailed statement of objections. In light of the same, interim order is considered as above.
All 3 matters.
Same thing for 7 and 8.
6, 7, 8.
Learned counsel so and so undertakes to appear for respondent 6 to 8.
No, 1 to 3.
1 to
In all
3.
3 matters.
1 to 3.
Colleagues' name may be deleted.
Items 6, 7, 8 are
Office
same, my
to-
lords.
Office to delete the name of Learned Counsel Madhukar M. Deshpande, shown as representing R1 to R3. Now these are all 3 are connected.
Same
issue.
Same issue, different projects, man.
6, 7 and 8 are clubbed and common interim order is passed No, but in 8, it's a different petitioner.
Petitioner,
issue is same.
issue is the same. Petitioners are
Reinvestigation.
same, my lord.
Same report.
Same petitioners.
Same report.
Projects are different.
No, reports are different or same?
Findings and the reports are same. And based on the Delhi High
No,
Court,
correct,
only, they're
correct.
again reinvestigating.
No, I'm asking if that report at annexure B is a common report in all the 3 cases.
No, different, my lord.
No, no,
Similar
Lords.
reports are passed.
Reports are
Different
different.
reports. Are
Similar report.
Yeah.
Yes.
With identical findings. Separate separate. The annexures of the reports are in 7 and 8 are
6, 7, my lords, reports are at B to E, annexure B to E. There are 4 reports,
just one.
4 different
Seal
projects.
number 7, reports at annexures
Annexure B to E,
B to E.
E lordships.
Notice is at
Notice is at annexure F, my lords.
F. Stay of annexure F. Reports at B to E.
F, G and H, my lords. My lords, there are 3 for 3 different projects.
F, G and
F,
H.
G and H, my
H
lords.
and J. F to J, my lordship, notice.
F, G, H, I, J.
J, yes,
In seal number 7.
7.
8.
8, my lords, the
Report is
report is at
annexure B.
annexure B.
Report is annexure
B.
B. Notice at
C to G.
C to G. C to G are stayed. Yes. Same order. Learned Council so and so undertakes to appear for R1 to R3. Offers to delete the name of Learned Council Madhukar M. Deshpande. Yes.
Serial number 9.
Grateful. We are obliged, my lords. Grateful.
9.
Yes.
BS.
Responding. But the parents were clueless as to why they were summoned to the college.
I'm very
They
sorry.
are
What
asking-
statements are made like
Just
this?
wait.
He's appearing
Let
for
him
the college.
complete. Just wait. Let us.
I have the voice record.
Let him finish. Yes.
Monday, Lord, when they came with the son. Lord, orientation was being conducted, so they requested to come on Tuesday. That is yesterday. Yesterday only the parents came in the first half. They said without the student, we'll be unable to talk to you. Student came and they were insisting that what the student has done is right. Lord, the object of my Lord directing them to come to the college was at least the parents as well as the student would apologize, would request. Their actions, their wordings, Lord, did not seem that they wanted to apologize for the conduct of the petition.
Yes.
I'm sorry. But on the court on the date on which Millet we appeared, they said don't come. Then I request my learned friend, he is aware. He called up to the dean and requested to appear on the next day. We appeared before the dean, sought for apology. Millet, he said consistently says, no, I will not hear you. Matter is ceased of the court. Whatever the court takes a decision, it is final. But I don't want to embarrass the court. I have the voice records, what he has stated, but I don't want. But all the allegations I have stated so in my writ petition, I have tendered apology on 5th when I faced a so-called inquiry. I tendered apology. Even the writ petition, I have tendered apology. But I am a final year student. But error is human. I understand that words need not have been uttered. But having regard to the fate of the student, not having regard to the, not even otherwise, not as on the law, I will point out.
Let's not get into law.
Yes, yes. I am saying that this will not happen. I will give an undertaking. Even the writ petition, I have stated clandestinely and made it clear that it is not going to happen.
Let them appear through VC, both. You ask your dean, parents and student to appear through VC. Appear through VC. I'll have it on Friday. No? Friday.
Permission ಅವರಿಗೆ ಎಲ್ಲರಿಗೂ ಬಿಡೋದಿಲ್ಲ. Registry-ನಲ್ಲಿ
That will arrange. That will arrange. That will arrange. You ask the parents.
Registry ಅವರೇ ಒಂದು ಲಿಂಕ್ ಕಳಿಸಿದ್ರು.
That will arrange. That will arrange. You ask him. So we'll fix a time on Friday. Let them log in through VC. VC link will be made available.
And Lord, the inquiry committee was formed earlier for this student. Lord, I have many of 7 professors, dean, principal, chairman of the institution, they were all sat together, they inquired, they gave an opportunity also. Lord, now, if at all, Lord, the dean has to take a decision, once again, the committee will have to permit him. He alone or even the principal alone cannot do so. That is also, if my lord were to say that I'll produce this committee report before the court.
The impugned notice
In fact,
itself,
the dean also stated to that effect. Now, because it has gone to a larger committee of 7 members, they have taken the decision and they have informed their decision. I alone now cannot take any action independent.
that cannot
Or
be
else
binding.
it has to be sent to the committee once again. There, my lord, the student and the parents, they can request the committee that whatever my learned friend said, if they were, my lord, it has to come from the student.
Correct, absolutely.
Absolutely.
If the student is not remorseful for what he has done, my lord, on record, the teachers have written letters to the dean as well as to the principal. They feel threatened to take classes where this person is, my lord. He is a 6-footer, 26-year-old, and most of the staff are younger to him. And my lord, in writing, if you were to threaten the dean and the principal, my lord may kindly consider what would be the fate of a staff member as well as a teacher.
Let us see, let the dean, now he has made allegation against the dean, isn't it?
Dean, how the? Against the dean as well as the principal. He has threatened to assault them. That my learned friend himself has produced.
No, I am
Let
not
us-
saying, I am not supporting the student
Let us see.
for the fact.
Both
remains.
in taking note of the nature of dispute, the petitioner and his parents, as well as the dean, the second respondent, to be present on through video conference on Friday. The registry to share the link with the
Yeah, the email ID
council for the
Provide the email ID.
email ID of the petitioner. as well.
council for the petitioner and respondent number 2. Necessary email IDs of the petitioner and respondent number 2 to be shared.
But I only one more request. But the parents are also may appear. Let them also.
Let them also be. Let us.
First may warn them. Because considering that his.
No, but if he threatens, then it's difficult to warn him. Let us see. Yes.
I'm
next.
not against Raghu Prasad. I
Yes,
sorry
let us-
for the first
let us see.
opening sentence.
Yes, next is.
10. Serial number 10, Raju.
Your Honors, this is a GST matter, wherein GST has passed an appeal without condoning the delay of 2 days. The delay was of 32 days. He has the power to condone under 104, 107(4) of 30 days. There is an extra 2 days of delay, which he is not able to condone.
In this matter, my lords, have been instructed to file counter.
File objection.
Please.
Your Honor, in that case, not to take any precipitory actions, Your Honor. Since the matter was of only challenging the JC order to be set aside, I haven't asked. This is for a interim order, interim relief.
There's no prayer as such for an interim order.
Interim order. So I only state that not to take any precipitory action because they'll start the recovery proceedings.
There is no prayer as such for an interim order.
Your Honor, it was on a short point of.
Correct, but you have to at least file an application. We'll consider it. You file it. I'll keep it open. You file it.
Next day, next week, Your Honor.
Yes.
I'll file an application, IX.
Relist the matter next week.
11.
Your Honor, date may be given.
It will come next week. I'll give instructions to the office. When you say next week, it has to come.
Much obliged.
11.
Please. There's the matter, my lord, your lordships heard last week. Your lordships will recall there were 8 adjudication order passed under section 73 of the GST Act. 8 issues were raised.
Just a minute. Shamant Naik, him
reconciliation between GSTR 2 and 3B. I pointed out that we have given the reconciliation, but the officer has not taken that reconciliation into account. He says no reconciliation is filed. Now, your lordships, my prayer is, and I filed a rectification application, that a rectification application was summarily rejected. Now, on the last occasion, if your lordships will recall, my learned friend said that a rectification order would be set aside and the matter can be sent back to reconsider the rectification. But the problem I will face, my lord, is that the appeal period for the other 7 issues will expire next week because the 3 months time is getting over. Now I have to file an appeal. Now, if I have to file an appeal, I have to file an appeal only against that 7 issues, because one issue will be if the rectification order only is set aside. Then one issue will be with the officer. I can't split the appeals. And system also doesn't accept if I have to pay 10% of the issues on which I am filing an appeal, the 5 crores, 10% I am ready to pay. But then I have to accept that the other 45 crores, I have to accept the demand and I will have to pay it immediately. So these technical issues will arise. So my suggestion was that the adjudication order itself may be set aside and let them pass a fresh order after taking my reconciliation into account, for which my learned friend says that he may have to take instructions for setting aside the adjudication order. So your lordships may let my learned friend take instructions. In the meanwhile, your lordships may stay the adjudication. According to me, no prejudice is caused.
Let us see, let them complete their instruction.
Yes.
So what is the interim order?
A stay of adjudication order, my lord. That is.
Annexure J.
That's right.
In light of the contention raised that the assessing authority has failed to take note of the reconciliation made by the petitioner between GSTR 2 and 3B and other contentions raised as regards other issues, there would be interim order of stay of order of adjudication at annexure J till the next date. Respondents are at liberty to seek for modification of the interim order passed upon completing their instruction and filing their statement of objections. Yes.
2 weeks. Well,
your lordship may keep it in orders so that the matter can be closed. They just have to take instructions which order has to be set aside.
Is the
2 weeks.
orders list after 2 weeks.
2 weeks.
Great.
Well, Sandeep.
Serial number 12, I appear for the petitioner. Manoj.
Yes.
Manoj, in this writ petition, Manoj, was challenged an order passed under section 245 of the Income Tax Act, in terms of which. Please,
just
Manoj.
1 minute. Who
I appear.
Third
For
counsel-
respondent number 1 and 2.
Third counsel Arvind Chavan accepts notice for respondent 1 and
1 and 2. Manoj.
Then
3 and 4, Mr. Tirumalesh.
3 and 4 Tirum.
third counsel Sri Tirumalesh is directed to accept notice for respondents 3 and 4.
3 and 4.
What is the matter?
Please, Manoj. Manoj, what has happened in this case is that a refund which has been determined to be payable to me under the Income Tax Act for the assessment year 2023-24 has been adjusted by the respondent number 1 against an order which has been specifically stayed by my lords in a writ petition. So the order against which the refund has been adjusted pertain to assessment year 14-15. The same petitioner has filed a writ petition before this Honorable Court challenging that order. By way of interim relief, this Honorable Court has stayed the operation of that order. So when
And now just point out the order of refund at annexure.
My lords, K, yes, Manoj. The refund has been determined in terms of the intimation at annexure K. It starts at page 176. Manoj. My lords have
Yes,
that.
where can we find this?
My lords, may kindly turn to page 195 because that's where the English portion begins, my lords. My lords have that.
Yes.
My lords, at the top, it's an intimation issued under section 143 subsection 1 pertaining to assessment year 23-24. Just below in bold, there's a table which says amount of refund, my lords. My lords can see that. Of 4 crore 16 lakhs 88,490.
Yes.
It is also repeated, my lords, on page 197.
So the refund is for a assessment year 23-24.
Please, yes, my lords. Now in the normal course, this amount of refund is to be paid to me. Under 245, my lords, there is an option given to the department, 245 subsection 1.
Yes.
Where he can propose to adjust, but rather he can adjust this refund against an amount which is payable by the SSC for any other period.
Now the demand has been raised for which year?
For assessment year 14-15, my lords.
14-15.
Yes, my lords. I have produced the writ petition. I have in fact produced the assessment order for 14-15 at annexure B1.
Page?
It starts at 28, my lords. The demand notice, my lords, will find at page 85.
So the assessment order.
Yes, my lords.
For the year 14-15.
Please, precisely.
Makes out a demand of
11 crores 13 lakhs 72,100.
Where do you get that?
My lords, will kindly turn to annexure B3, page 85.
This is the demand notice.
Yes, the demand notice issued consequent to the assessment order, my lords.
Yes. Where is the stay of this?
Yes, my lords, may kindly turn to annexure D, page 146.
Yes.
My lords have that one. Page 146, my lord.
Yes.
That is an order, interim order of this honorable court dated 22nd June
That
2000.
A1, E2 and A3 are the assessment order and demand notice.
Yes, my lords will see the reference to A1, A2, A3 at the bottom of page 148. There's a note which is provided at the end of the interim order.
Yes, yes. So this is for the same year of 14-15.
Yes, yes, ma'am. That also, my lords, will kindly find at the computation number, my lords, will see the DIN number also tallies with this.
Yes.
And the
Yes.
order date. So I brought it to my to the first respondent's notice because in accordance with law, he issued me a notice saying I propose to adjust the refund. I responded to him saying, no, please don't do that because the demand which you're proposing to adjust against, I have challenged in a writ petition. This is the writ petition number. This is the Honorable High Court stay order. So please don't adjust it. Notwithstanding the same and without even an opportunity of hearing, he goes ahead and adjusts it by way of the intimation at annexure A.
Now the interim order is passed on
22/6/2023.
and you have brought it to their notice?
My lords, may kindly see at annexure P in June 2024.
Annexure?
P.
P.
Page 218. 218 minutes.
216 and 218, both are there, Manoj, because these are all online proceedings. 218 is the physical letter, as my learned friend is submitting. 216 is the online response.
So earlier to this adjustment itself, you brought it to his notice.
Yes, yes, very much so, Manoj. The impugned order came to be passed on 20th of June 2024.
Page?
Annexure A, page 25, Manoj. My lords have that.
Yes.
My lords, may kindly see on the following page, page 26, my lord.
Yes.
My lord, in these matters, it so happens, my lord, that the concerned assessing officer has to remove that for this particular, there is no demand, my lord. Then the CPC, they only take the data from the concerned assessing officers, whatever they have uploaded, and then they adjust, because in the this thing demand register, it will be showing that there is a demand of 11 crores against this assessee. So he would have adjusted it, my lord. I'll take instructions, my lord, whether the concerned assessing officer has removed it because there is a stay on this particular.
No, correct, but even otherwise, now you have to give it back to him.
Yeah, that's what I'll take instructions. A week's time, that's all.
Learned counsel appearing for the petitioner. I'll just make a small observation. Submits that the order of refund for the year 23-24, which had been granted, could not have been adjusted to the demand as regards the assessment order passed for the assessment year 2014-15, as there was an interim order of stay in WP 12286 of 2023 as regards the proceedings of the assessment year 14-15, including the demand notice. Accordingly, it is submitted in light of the interim order of stay on 22/6/2023 passed in the writ petition, and petitioner having intimated the authority regarding order of stay on 27/3/2023.
2 minutes.
On
18/6/2024.
On 18/6/2024, the impugned act of adjusting refund at annexure A, date on passed on 20th June 2024, could not have been resorted to. Full stop.
I'm sorry, my lords are right. It is 27/3/24 and 18/6/24. I'm sorry.
27/3/24 and
18th June 2024.
18th
June, 18/6/2024.
Intimation data. For the say of the full stop. Prima facie, the claim made by the petition in the writ petition requires consideration at the hands of the revenue. Full stop. Stand of the revenue by the next date. List the matter in the same stage on
30th or 31st next week.
30th of
31st minute.
31st. Yes.
Much good.
It so happens because of stay, we cannot recover the balance amount of for that particular assessment year 14-15, my lord. But only because of stay, the demand cannot be erased in the portal. So the demand reflects. If it is the stay has been, the assessment order has been annulled or set aside, then the demand is removed, my lord. Now, because of stay, the demand remains. So CPC, it's more like automatic. As the demand is there, so I adjust it. That is I'll just take instructions.
Say number 13,
Much
Prashant.
Serial number 13 and 15 can be taken up together, my lord. Same issue.
Yes.
Can I request my lords to have serial number 15 first, my lords? And give a full picture in 15, and then 13 is a follow-up of that.
You
Yes, Laxman. Yes.
Then Council Shri Dilip accepts notice for the respondents. All respondents.
Please, lords.
Yes.
At 13 and 14. Lord, serial number 15 essentially is a reassessment order under 147 and a subsequent demand notice that has been issued. In serial number 13, the reassessment order is for 18-19, my lords. Serial number 13 is an order under 148A-D proposing to reopen. This is for the year 1920, my lords. Because essentially, I am a real estate company. I invest in various properties and projects, my lords. Now, I was incorporated in the year 1986 in Bombay. I was operating in Bombay till 2005, and then thereafter I moved to Bangalore. My registered office itself moved to Bangalore, my lords. My lords may have page number 86 for a moment, my lords. This is the National Company Law Tribunal's order. 87, my lords, is the order.
Yes.
Registered office from state of first paragraph. Memorandum for company for shifting of registered office from state of Maharashtra to state of Karnataka as approved by special resolution passed in accordance with section 189.
You're reading at page?
87, my lords.
Yes,
First paragraph, my lords.
yes.
The middle, my lords. Registered office from state of Maharashtra to state of Karnataka as approved by special resolution passed in accordance with section 189 of the Companies Act 1956. And then thereafter, my lords, they approved the scheme, my lords. At page 90, my lords, is my PAN card. Just one word in the, one letter in the PAN card, my lord, AAGCA0657A is the PAN card. This is operational from 1986, my lords. So I've been filing all of my returns, yearly returns under this PAN card, my lords. Sequentially, my lords, if I take my lords through what has happened, 16, 17, 17, 18, my returns get taken up for complete scrutiny. They issue notices, I respond, they agree, disagree, final orders are passed, my lords. For 17, 18, my lords may have annexure H at page 200. It gets picked up for reassessment under 148, 148A.
At page
200, my lords, annexure H. 201, my lords. The second paragraph.
Yes.
Inquiry was initiated against Messrs. Potential Trade Link Private Limited by the office in Bangalore. During the course of investigation carried out by the office at Bangalore, it was found that Potential Trade Link was making regular transactions of large amounts with Messrs. Avant-Garde Fashion Wear Private Limited. PAN is a different PAN number, my lords. The name of the entity is Avant-Garde Fashion Wear Private Limited, which is me, but the PAN is a different PAN number, my lord. And what is ironic to note, my lords, is the letter J is mentioned. The J would indicate there is an artificial juridical person, my lords. Now, basis this, my lords, they say that income has escaped assessment, etc. And they issue notices to me, my lords. My lords may have page number 204 for a moment, my lords. The typed copy is a better reflection of what has happened. Now, these are the 4 years, my lords. 1920, 2021, 2718, 2018, 2019, my lords. For my lords, 2017 and 2021, my lords, these 2 years, they have issued notices to me under the same explanation that this other PAN, you have not reported transactions. They're a non-filer, and therefore, my lord, income has escaped assessment. So I respond. I respond to both these notices. I bring it to their attention that this is not my PAN. In any case, the transactions that you have assumed, which has escaped assessment, etc., have been reported in my PAN, in my regular assessment. That order, my lord, may have at page number 20. My response is at 207, my lords. Just for a moment, I can take my lords through that response.
No, well, then what happens?
They pass an order closing the assessment for 1718 and 2021, my lords. Now, when I file the response for 1718, my lords, the officer brings to my attention that there is another notice that has been issued to me in my Bombay address. I don't have an address in Bombay. The Bombay address has been issued to me. There's a notice that has been issued to me, and a notice for reassessment has been issued in the Bombay address. So I'll just take my lords first through annexure L, which is page 211.
Now they close it for 2 years.
They close it for 2 years.
Which are the?
This is for 1718, my lords. This is the order for 1718. My lords may see at the top, name of the entity, address is in Bangalore. And then my lords may have the PAN just at the next box, which is the PAN which I report transactions.
Page
211, annexure L.
Yes.
My lords may have page number 215 of the order.
Yes.
Para 5, my lords.
Yes.
The details submitted by the SSC are verified. The company has given copy of ITR balance sheet, profit and loss account and computation for income for the assessment year 17-18. It is verified that the assessee company is filing its return regularly with so-and-so PAN, which is the PAN that is under my name. And for assessment 17 year, assessee has filed its return of income under the heads other income on 30/10/2017 with loss of 23 lakhs. Regarding information of sale of property and interest income, assessee has offered interest income as part of the income of the return file. And then they go on to assess the various other items, my lords. My lords may have page 216, the next paragraph. Somewhere in the middle, my lords, but sixth line.
Yes.
Details of assets and liabilities of the directors are submitted. As on so-and-so day, director has assets of so-and-so in the capital account. It is seen that the director has sufficient sources to lend loan to the assessee company. Similarly, the ledgers of the recipients were also submitted by the assessee company. It is seen that most of the transactions were in the form for loan payment and repayment and do not form the nature of business receipts. Since there is no income which has escaped assessment, it is held that it is not a fit case for reopening. So this is for 17-18 insofar as the Bangalore address is concerned, my lord.
Yes.
My lords may have the next page, 217. Same entity. Address is a Bombay address. PAN is the J PAN, the artificial juridical person PAN. Now, because I did not have a notice to this and the officer brought to the notice that this notice has been issued to me, I tell him, you please consider the response that I have filed for this as well. So he responds, he takes my response on record, and at page 221, my lords, he reproduces it. Para 6. Page 221, my lords.
Yes, then what happens?
So 17-18 proceedings are closed completely. Similarly, 2021 also proceedings are closed, my lords. Now, my lords may have annexure A, which is what is in question in this petition, my lords. Page 74.
Yes.
Now, my lords, this is for 18-19. Assessment order is passed completely, creating a demand of 72 crores, my lords. Now, in terms of procedure, he has been absolutely pinpoint in terms of procedure, my lords. He has gone through the entire gamut of 147,
So
148, 144.
Insofar as all these years, you have filed return under your PAN.
Absolutely, absolutely. So my recommendation, my lords, is this. This matter can be sent back. Let the bank, now that the matter has been transferred to the Bangalore Commissionerate, let the Bangalore Commissionerate have a look. I will file responses before the Bangalore Commissionerate completely. And I will justify to him that I have filed all of these under my regular PAN in Bangalore. All of these transactions are captured as part of my Bangalore PAN.
Lordships may kindly let them file reply, my lords, because they have not appeared before the assessing.
Reply for?
Lords, let it go to the stage of show cause notice, my lords, at page 77.
Now, the
Notice
present
under section
petition.
If there is the assessment order in this.
Assessment order.
Please,
Yes, my lords.
Page?
Page 77.
Yes.
So your lordships may kindly consider to remand it to the stage of show cause notice under section 144. Let them file a reply, my lords, let the assessing officer consider and pass.
Yes. Now, this is as regards to the address at Mumbai and PAN number. Now, this is for the year 18-19,
my lords.
18-19.
So
what you pointed out was for
17-18 and then 2021 also, my lords.
Now for 18-19.
18-19, there's an assessment order that has been passed in this petition.
No, correct. But for 18-19,
my lords,
you have filed returns in the earlier PAN.
in the regular PAN, yes.
And that assessment order is passed.
That regular assessment has been done for that. In fact, it has not been picked up for reassessment at all by the Bangalore Commissionerate.
So where do you get that?
That there is no notice that has come to me, my lords.
No, but your assessment order,
yes,
your filing acknowledgement is the assessment order.
Assessment order. I'll place that on 191, my lords. My lords may have.
Let them make the submission. Let the assessing officer verify that, my lords, whether they've offered it.
Yes.
Then let the assessing officer.
the petitioner. Now, the present petition 19289 is only for 1890.
1819, my lords. Annexure A and Annexure B, because they've issued a subsequent demand notice as well.
They've challenged only the assessment order in this, my lords.
The petitioner in WP 19289 of 2024. The petitioner has sought to challenge the assessment, reassessment order, is it?
Reassessment order under 147.
Reassessment order at Annexure A, as well as demand notice at Annexure B as regards the assessment year 2018-19. In the case of the petitioner, the assessment order has been passed as regards to the same entity, namely Avant-Garde Fashion Wear Private Limited, for the year 2018-19 as regards PAN number AAJA0012A. Full stop. It is submitted as regards to the same entity. The petitioner has already filed returns for the year 2018-19, which has attained finality as the said assessment has not been reopened.
My lords may have that filing at page 123, my lords, for 1819, the acknowledgement.
Full stop. Reliance is placed on the acknowledgement for having filed returns as regards the petitioner under the PAN AAGCA 0657A for the assessment year 2018-19. Accordingly, it is submitted that the order at Annexure A relating to a different PAN and proceedings initiated by the department in the state of Maharashtra cannot stand, as for the same period of assessment year 18-19, the return has been filed before the authorities at Bangalore. Next, Learned Counsel for the respondent submits that this aspect as to whether petitioner under the PAN number acknowledgement is at page
123, my lords.
Under the PAN number AAGCA 0657A has filed returns for the year 2018-19 is a matter to be looked into by the assessing officer and is a finding of fact to be recorded. Full stop. Next. Taking note of the contention, prima facie, it appears that the petitioner has filed the returns for the year 2018-19 under the PAN number AAGCA 0657A for the same entity, and the assessment order at Annexure A has been passed for the same entity, though under a different PAN, namely AAJA0012A. In light of the above, it would be appropriate to set aside the assessment order at Annexure A and the demand notice at Annexure B and remit the matter back to respondent number.
It's faceless, my lords. It's faceless.
Correct. remit the matter back to the assessing officer to reconsider the matter at the stage of post.
Respondent number one, respondent number one.
Respondent number one to reconsider the assessment proceedings which were a subject matter of the order at annexure A from the stage of post show cause notice. Petitioner is at liberty to make out his reply to the said show cause notice, and the respondents would consider the matter thereafter as per law. All contentions are kept open. Now, which is the other matter number?
Serial number 13, my lords.
This is 15. IA 1 of 24 is allowed. Petitioners dispense with production of so and so. Yes.
Serial number 13, my lords, is a challenge to 148A D order proposing to reopen.
148A
D.
For which year?
For 1920, my lords.
So this you go and then you okay. So then AB notice you have to reply.
AB notice.
Plus, this is issued, my lords, by the Bombay office.
That also.
Plus, the assessment order was, please, my lords,
That is faceless.
please, my lords. This is in still a pre-assessment stage, my lords. They have challenged 148 AD, my lords. They should approach the Bombay High Court, my lords, because this was issued.
Here, my lords, I don't have an entity that is based out of Bombay at all.
Correct, but the
issuing authority, my lords, jurisdiction
is at Bombay.
If that was the case, my lords, then the Bangalore Commissionerate should have issued a notice to me.
No, you're right, but now you'll have to appear there and.
No, but my lords, from what I understand, my lords, this by way of page number 65, my lords, the this 148 AD notice has been communicated to me by the income tax officer in Bangalore, my lords. This is how I come to know that the notice has been issued to me.
You find out.
Please.
In light of the contention that the petitioner has, where is the notice?
The notice, no,
148 AD order is at page 61.
No, return.
Page 125, my lords.
In light of the contention of the petitioner that he has filed, that it has filed returns for the year 1920 before the authority at Bangalore as regards PAN number AAGCA 0657A, and as regards the subject matter of the same assessment proceedings, the fresh proceedings are sought to be made out as regards a different PAN number, that is AAJA 0012A, and order passed under 148 capital A small d. There would be stay of the order at annexure A. The Learned Counsel Dilip accepts notice for the respondents, but submits that he would have to obtain separate instructions in light of respondent 1 and 3 being situated in Bombay. This is the matter after 2 weeks.
I'm grateful.
14, Sandeep. Serial number 14.
Stay in connected matters.
Here for the petitioner. my lord.
Stay in connected matters.
There is a stay in
Corporate,
connected.
yes, corporate guarantee, my lord.
Page?
Annexure P1 at page 196, my lord.
196.
Counsel for the petitioner submits that the identity as regards the identical legal condition raised in WP 12498 of 2024. An interim order has been passed. And the benefit of such interim order may be extended in the present case, which has also raised an identical issue. Full stop. Interim order passed in WP 11681 of 2024 reads as hereunder, page 196. Annexure P1. Accordingly, there would be an interim order also in the present matter. And the respondents are restrained from taking. What is the interim order?
My lord, stay the operations of annexures A1 and A2, my lord.
There would be an interim order of stay at annexure A1 and A2. Then Council, who
I'll take notice, my lord, for 1 to 5.
Then Council Chamant Naik accepts notice, respondents 1 to 5.
6 to 9, my lord, I take.
6 to 9.
Yes.
Then Council G1 accepts notice. A1 of 24 is allowed. Petitioners dispense with production of sons. Yes.
16, Ravi Raghavan, 16.
Please.
Yes.
Please. There's a challenge to the order at annexure A, my lords, and a corrigendum based on which the order was passed at annexure A1. Should one of the respondent number 2. The issue, my lord, is I am Air Asia operating flights within India. I operate only the domestic travel, my lord, within India. Whatever tickets I am selling, I have paid tax on it. GST, I have paid appropriate GST on those transactions, my lords. Air Asia, my lords, has different group entities in other countries. For example, in Malaysia, Air Asia Bharat, they operate international flights. Some of them originate from India and some of them, my lords, operate outside India. In regard to those flights also, my lords, a customer, a passenger can book tickets on my website. For example, if I have to travel, say from Singapore to Kuala Lumpur, I book tickets on Air Asia India's portal. I make the relevant payments. Because that flight is not operated by me, that money, my lords, goes to the other entity. This happens the reverse situation also. A customer or passenger sitting in Singapore can book for a journey within India, say from Bangalore to Delhi. He can book it in the portal of my Malaysian entity, make payment there. That money comes to me, I discharge appropriate GST on the transaction. This, my lords, intercompany adjustment of money or collection of money and transferring the money, my lords, is happening because of various agreements that we have. The case of the department, my lords, is that whatever money I have received or transferred to the other entities, that, my lords, is an import of service. And therefore, I am required to pay GST on that transaction. On that basis, my lords, an audit objection was raised. A show cause notice also was raised, proposing to demand GST on this amount, saying it is an import of service, therefore pay GST on this transaction. My lords, may kindly come to the show cause notice itself directly, my lords, at page 199, because it is all based on audit objection. Number of objections are raised. At page 199, my lords. It's the show cause notice, my lords. It starts at page 195. At page 199 is the relevant transaction which we are concerned with. Para 3 in the middle, my lords. My lords have it. Non-payment of GST and a reverse charge basis on import of services. This is based on an audit objection.
Upon verification of the financial statements, additional documents submitted by the RTP, it is observed that the noticee has transferred the amount of 2 crore to 2,863.82 crores to AirAsia Bharat, Malaysia. The said transfer falls under import of service and liable to GST under reverse charge basis on the said transaction. Therefore, the noticee is liable for reverse charge basis in terms of section 5(3) of the IGST Act. The noticee has to submit the compliance, etc. I challenge this. This is how the notice was issued, proposing to demand. I challenge this, attend a personal hearing. After the personal hearing, my lords, beyond the due date specified for issue of a notice for this relevant year, this is 2018-19, a corrigendum came to be issued at page 78, annexure A1. My lords may kindly see page 79, completely making out a new case in the corrigendum. The second paragraph, my lords, they extract the earlier para in para 3, which was there in the original notice. Then, my lords, the nature of transactions involved were, I'm reading in the middle of the page. My lords have it? Page 78, middle of the page. The nature of transactions involved were inadvertently referred to as imports of services in the show cause notice issued, whereas the same shall always be read as under. They make a completely new case saying it is advance for tickets. And since it's advance for services, you are required to pay GST on this. This Manat's corrigendum has been issued to me on 11th of March 2024. The time limit for issue of a notice for the year 2018 was 31st of January 24. Because Manat, for the year 2018-19, the order for any notice issued under 73, the last date for passing of the order was 30th of April 24. And the law provides that within 3 months from the date of the order, notice to be issued. Therefore, before 31st January 24, if at all they wanted to issue a corrigendum, change the notice, they should have done it before 31st of January 24. This corrigendum, my lords, is what is adjudicated now in the impugned order, giving up their case that it is an import of service, now fastening a tax liability on me on the ground that this is an advance and therefore I am required to pay GST. My lords may please come to page 68 of the impugned order, annexure A. Page 68, my lords, have the issue number 3 in the middle of the page. Non-payment of GST on advance receipt, my lords, have it. And page 70 is the conclusion. Page 69, it starts. The learned authority.
You have objected to this corrigendum.
Yes, when I objected to this corrigendum, saying this is beyond the show cause notice. And in any case, on merits, I said it is a transaction in money. And transaction in money is out of GST law. Therefore, no GST is payable.
Let us see. Yes.
Seek instructions.
What about interim prayer?
Lordship may have it next Tuesday, my lord.
In fact, on a similar issue for the earlier year 17-18, this honorable court has already seized the matter. At page 115, my lords, is an interim order. There the issue was on import of service, on advance, etc. This honorable high court was pleased to grant me stay at page 115.
Similar contention.
Yes, similar. See, this is 2018, that is 2017. Because my lords, this one is called as SOTO, that is sale outside, ticketing or ticketed outside. Those are transaction, intercompany money transactions happening, and that is one transaction in money which is out of GST law.
Let us see. In light of the contention of the petitioner that the earlier show cause notice was sought to be amended by virtue of a corrigendum on 11/3/2024, and as regards the assessment year
17-18 minutes.
17?
The earlier order minutes?
No.
This is for 2018-19.
With respect to the assessment year 2018-19, the last date for issuance of show cause notice.
Issue of an order is 30th of April 24.
Last date for issuance of an order was 31/1/2020.
Issue of a show cause notice is 30th. Issue of order is 30th April 24. And consequently, notice is within 3 months from there before that. That is 31st of January 24.
Last date for issuance of show cause notice is 31/1/2024. And the corrigendum could not have been issued after such date. there would be an interim order of stay of
Annexure A and A1 minutes.
annexure A and A1, full stop. The further submission that in the case of the same SSC, in WP 21182 of 2023, interim order was passed, is also taken note of, full stop. Adinnondu sati ಹೇಳಿ ಏನ್ ಬರ್ದಿರೋದು? Corrigendum dated 11/3/24.
Annexure A1 is there.
31/1/24. Yes.
Let me only stay of annexure A minutes. A1 is the
stay
A is a
of-
consequence.
And
Annexure A only.
interim order of stay of annexure A.
Because A1 is only the notice, that's the order is A.
Now this has to be clubbed with that earlier.
Can do.
List along with the WP number
21182 of 2023.
21182 of 2023. Shamant Naik accepts notice for the correspondence.
But the office objection is on giving the original because these are all online
Of
filing.
24 is allow petitioners dispense with production of certified copy of annexures A and A1. Now some order must be passed. Why every time they have to file an IA, isn't it? Yes. The registry, wherever it's online, should
Yes.
not insist so that then again they file.
Yes, sir.
Shall we make an observation here to take note of it? What is your submission that these are online?
These are all received online, my lord. Therefore, we take printouts and then file a copy here because these are all to be served online also. Online put in the
Just
GST.
point out.
Service of order online. 7310 Allah.
Page 72.
Page
72. This is digitally signed.
Digitally signed. Now, despite this, the office has raised the objection. What is the objection raised?
That my lord, original certified copies have not been filed. Subjection.
Lordship may observe that.
It is noticed, counsel for the petitioner. No, but there's no office objection, but they insist, is it?
They insist.
At the scrutiny.
Yes, my lord.
Scrutiny
Yes.
stage. The petitioner has filed application IA 1 of 24 seeking for dispensation of production of certified copy of the order of adjudication dated 24/4/2024 as well as the corrigendum dated 11/3/2024. Full stop. Third counsel for the petitioner submits that in many of the matters, as in the present case, the petitioner, the counsel for the petitioner is asked by the registry to file application for dispensation of the order wherein which is sought to be set aside. Full stop. It is submitted that in all in all matters where tax authorities have passed digitally signed orders
And are uploaded online.
And uploaded electronically.
uploaded
Electronically.
In the portal.
electronically on the portal. Insistence of certified copy ought not to be made. Stop.
Let's continue record uploaded electronically, which is a valid service in terms of the CGST Act. It's a valid service.
Which is
116.
uploaded electronically.
Which is a valid service in terms of section 169 of the CGST Act.
Which is valid.
Service of notice, service of notice or orders.
Valid service of notice of order
Notice
terms
or
of-
orders. Notice or orders in terms of section 169
169 of
CGST Act 2017.
CGST Act 2017.
And rule 140.
Office to the registry to take note of the above submission to counsel for the petitioner appropriately. Copy of this order to be marked to the registrar judicial.
Obliged, great, deeply obliged.
17.
Petition. I placed a
Yes.
memo on record. They have sent an email communication which I have extracted from the memo minutes. It is a shifting case. There are some issues with regard to mapping. Now they are doing it minutes. They have what they have said. They have to coordinate with the state authorities, and tomorrow they are going to open it for provisionally to issue the necessary provisions for uploading their details to students. That memo will be taken on record. I have served a copy to him. Tomorrow they are going to do that.
My lords, in the memo it says provisionally allowed, my lords. The affiliation was granted almost a year ago. And with only 1 week left for the examinations to begin, now how can they say there are discrepancies?
It's not discrepancy minutes. While shifting, it's a shifting case. That's what I have been informed. If you want, I can give the full details. Then all details were not provided. So because of that, mapping has not been on time. That's the issue what they have raised. They are going to do it. They have appointed a committee and they are looking at it and they are going to do it. And tomorrow, just now I spoke to the concerned officer. He said that tomorrow they are going to make a provision in the portal itself. They will come to know about state also as they will be informed the petitions. That's what has been said in the.
So we'll relist it on
24th, 24th or 29th, Monday.
on Monday.
Monday. By the time these things will be taken care of. I informed them. There is no
That
issue on
counsel
this.
Shri M.N. Kumar
This memo may be taken on record. The contents of the email I have extracted.
has filed a memo which is taken on record.
Copies I will
It
circulate
is
them.
submitted that the issue would be resolved
No, in terms of this memo, that will be more.
in terms of the memo. Relist the matter in the same stage on 29th in the orders list.
And I will ensure that, I will ensure management, there won't be any difficulty for them. Whatever needs to be done from the department side, they have said they do it.
Much obliged. 18. 18.
Appear for responding, my lords.
I appear for respondent 6 and LRs of R7.
Lords, the matter has
So the registry has put up a note that the inquiry should be not only as regards IA 5 of 22, but IA 1, 2 and 4 of 22.
Yes,
That is the.
yes.
That's
May I bring your lordship's kind attention
No, no,
to order?
No, if it is correct, we will clarify that. That's,
May I make one submission?
that
Lords?
observation
This-
is correct. Observation of the registry is correct. That
Observation
inquiry has
is
to-
correct, but
Yes.
one thing is your lordship's order on IA 1 of 2024. That is on 14/3/24 dated.
On
14/3/24. Order sheet dated 14/3/24.
yes,
May I read?
yes.
Alternate counsel appearing for the respondents has filed IA 1 of 2024, seeking for recall of the order dated 27/2/24, allowing IA 1 of 2022, IA 2 of 2022, and IA 3 of 2022. In the light of the admitted facts, as made out on hearing both sides, and as both sides submit that the order has to be recalled and the pending IAs have to be heard afresh. In the light of the said stand of both sides, the order dated 27/2/2024 is recalled. IA 1 of 2022, IA 2 of 2022, and IA 3 of 2022 are restored. IA 1 of 2024 is allowed both sides to file synopsis regarding pending IAs. Office objections on pending IAs needs to be complied by the next date of hearing. List this matter on 21/3/2024. Thereafter, on 3 dates, there was no representation for the so-called beneficiary of the petitioner. Ultimately, they filed their affidavit along with one copy of the suit decided by the civil court, where we are not the parties. We are not the parties. So had we been the parties there, I would have brought it to the notice of the court that this document, which is called as release deed, it's a fake document. Therefore, my humble submission before your lordship, I will read what are the IAs. I will read what are the IAs. Your lordship may kindly see IA number 1 of 2022. It is filed under section 5 of the Limitation Act. As far as impleading applicant is concerned, there is no application for condonation of delay as far as LRs of 7 R7 are concerned. Next, IA number 2 of 22, Order 22, Rule 9 CPC for setting aside abatement as far as impleading applicant is concerned. There is no application for setting aside abatement as far as LRs of R7 is concerned. IA number 3, Order 22, Rule 4 CPC to bring the legal heirs of R7 on record. Idon sariyagide. There is no application for setting aside the abatement. There is no application under section 5 of the Limitation Act for these to bring the LRs of R7 on record. Now, IA number 4, they have filed it under Order 22, Rule 7 CPC, which is not applicable for this case. This also to set aside abatement as far as impleading applicant is concerned. This also. So there are no proper applications filed in this case, and I have filed serious objections for IA number 1 and also IA number 5 of 22. All these applications are filed on 21/10/2022. Even though it was filed on 21/10/22, copies were not served. They were served only in the month of February 2024. Anyhow, I have filed my objections even before copies were served on me. Therefore, here there are procedural lacunas. The advocate who filed these applications has given his NOC to the present advocate, and he has also not applied his mind for all these applications, whether what is wrong with these applications.
May I make one submission also? I think we have to cut short this now because we have been running around this procedure for the last 1 year. I will make one submission to see that all the things are sorted out at one shot. I would only seek your lordship's permission to withdraw all these applications because the earlier concept, I am not able to comprehend all these IAs and convince the court because there are certain wrong provisions that are mentioned and certain applications which are wrongly filed seeking for bringing the LR or the
So you-
successor in interest of the
Correct. So
petitioner.
you filed up.
Now, if your lordships permit, may I withdraw all the applications with liberty to file fresh applications so that
You, you filed the fresh application.
Yes,
with a memo to withdraw all these.
yes, I will
We'll
file
consider.
necessary because we have to sort it out. Your lordships can see the order sheet.
ಈಗ
This is going on for last 10
ಇವ್ರು-
hearings. The
ಇವ್-
same thing has been going on.
ಅಲ್ಲಲ್ಲ, according to
And
the
probably I
council,
feel-
it is, ಇದೇನೋ this is pending for the last 1 year ಅಂತಾರೆ. 1 year ಇಲ್ಲ ಏನೂ ಇಲ್ಲ. ಇನ್ನು ಇವ್ರು ಬಂದಿರೋದೇನೆ ಜನವರಿನಲ್ಲಿ. ಈಗ we are in ಇದೇನೋ 7th month.
I will concede whatever my learned friend is saying. It is my mistake, my earlier council's mistake, petitioner's mistake. All mistakes I will concede, my lords. Permit me to file because
ಅಲ್ಲ, ಈಗ
this,
ಹೇಗಾಗತ್ತೆ? See, ಈಗ ಅವ್ರು ಹಾಕಿದ್ರೆ whatever right that has been accrued to these respondents will be lost.
how it
No,
is
we'll
lost.
see.
ಹೌದು.
No, that we'll see. Let him file whatever he wants to file. We'll see what is to be done.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಈಗ ಇದನ್ನ ಅವ್ರೇನಾದ್ರು ಹಾಕಿದ್ರೆ ಪರ್ಮಿಷನ್ ನೀವು ಕೊಟ್ರೆ,
I am not going to give permission.
Huh?
I am not giving permission.
yes,
Let them file what they want.
ಅಷ್ಟೇನೆ.
Then we'll consider.
Very well.
You
I will
file-
file, my lords, necessary memo to withdraw with liberty. Your lordships may consider on merit with regard to liberty. Let him file objections. My lords, if these technical things are to be taken so seriously by my learned friend, my lords, I will also come out
But
with
you
that.
place on record.
ಖಂಡಿತ.
Whatever you want to file, you place it.
I will file it. I
We'll
will file.
consider. When do you want it?
My lords, Monday or Tuesday, I'll file.
ಮಂಡೇ.
1 week ಆದ್ಮೇಲೆ ರಿಸಾಲ್ವ್ ಮಾಡೋಣ ಬಿಡಿ. ಸುಮ್ಮನೆ ಯಾರೋ ಹಾಕಿರೋ ಎಲ್ಲೆಲ್ಲೋ ಹೋಗ್ತಾ ಇದೆ.
ಶಿವಕುಮಾರ್.
You file it and then you move.
I am only trying to say that, my lords, we will have to put an end to this
No, that is-
procedural lapse. Maybe I admit, I concede
ಅಲ್ಲ,
there is a procedural lapse.
2011ನೇ ಇಸ್ವಿ ಕೇಸು ಇವರು 3 ಸಾರಿ ಇವ್ರು ಬಂದೇ ಇರ್ಲಿಲ್ಲ. ಅದನ್ನ ಇವ್ರು ಕನ್ಸಿಡ್ ಮಾಡಲ್ಲ, ಬೇರೆ ಇದನ್ನೆಲ್ಲ ಹೇಳ್ತಾರೆ.
ಸರಿ ಸರ್, ನಾನು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತೀವಿ, ಇಲ್ಲಿ ಬರೋದಕ್ಕೆ ಲೇಟ್ ಆಗೋಷ್ಟೊತ್ತಿಗೆ
ಹೌದು.
that cannot be an allegation.
ಅಲ್ಲಲ್ಲ.
I am sorry, this happens to
ಇಲ್ಲ,
everybody.
ಇಲ್ಲ.
Learned counsel for the petitioner. Relist the matter. Next week. I can't give a date because we'll see what happens. There'll be some.
I
changes.
understand.
There'll be some changes.
Oh.
But you've, either of you, after a week, you file a memo. See how it, how to have it posted.
But your lordships may kindly notice this matter is by special orders, it is posted before lordships.
ಹೌದು,
ಅಲ್ವಾ?
ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅದು.
This is by special orders, my lords, it is coming before lordships.
And only go to- No, if correct, if I'm sent outside, file has to come, no?
I understand.
So
I will file a
I'll only
necessary
say
memo.
next week, whatever it is, one of you move a memo. I'll have it listed wherever I am.
Dismiss?
I'll have it listed.
Yes, yes, ma'am. Yes, ma'am.
19,
Obliged.
Raghavendra sir, 19.
But 19 is essentially the issue involved is the intermediary services, my lord. There is a batch already in.
No,
serial
there's
number
already
7.
an interim order passed.
Yes, my lord.
Huh.
Let the intermediate orders continue and tag with serial number 75, my lord.
List along with serial number 75.
Even
interim order-
20.2 also, my lord.
Just 1 minute. Interim order earlier granted is extended till the next date. Then serial number?
20.2, that also involves.
No, no, Lord Speaker. Those new.
My lord, so far as serial number 20 is concerned, my lord.
No, just
far
wait.
as-
Just,
Lord,
no,
These
just
are,
wait.
my lord, these are all, this is the pertaining to, my lord, period when the service tax was in this serial number 19
Yes.
and I think 20 also.
Yes.
My lord, the pleadings are complete in these two matters, I believe. Now, my lord, in some of the matters. which have
And
been
my lord, in fact,
recently
this-
filed,
Just 1 minute, just 1 minute.
Some of the matters which have been filed recently, my lord, pleadings are yet to complete.
So we'll keep it separate. not to link.
My lord, this, the,
Now,
aspect about.
may I kindly not club with each other. It may be posted along with that, my lord, on the same day,
Same.
but not, my lord, interlink with.
Okay, let us interlink.
My lord, see, the reason why we are seeking for tagging is the issue as to whether intermediary or not. That is the issue which is being decided in 75. Same issue is also involved, but the levy was under service tax in the 20, serial number 20, and 75 it is a GST.
No, it's
The
okay.
issues are same, my lord.
No, I will adjourn it on the same, if I say next week in this, that also I'll say next week. We'll
Let
see
the
it.
matter be posted together, but let it not be tagged.
Interim order earlier grant is extended till the next date. This is the matter week after next. 19.
Serial
Yes.
number 20.
20.
My lord, so far as,
Yes.
my lord, so far as serial number 20 is concerned, my lord,
Yes.
your lordships had heard this matter, my lord, when your lordships were holding the roster earlier. Pleadings were complete, and my lord, the matter on hand is squarely covered by the judgment of Reading. What the SSC has done by placing, my lord, certain circulars and challenging its wires has taken the stay on the show cause notice. No, my lord, the challenge as to the stay, I mean, the authority to issue the show cause notice has been squarely settled, and my lords have heard this matter on as early as 19/7/2023, my lord. My lord, there is nothing that remains, and my lord, revenue may be permitted to take its logical stand. My lord, after taking the interim order, my lord, the matter has been dragged. Absolutely, my lord, the prayer that is made in the writ petition does not survive for consideration, my lord. Your lordships had heard it when the lordships were had heard it on the last roster, my lord. 19/7/2020. From then, my lords, the matter has been dragged on. It is, my lord, only on one judgment, my lord, will make submission. Your lordship may hear it at 2:30.
My lord, we are ready for the arguments.
Please, my lord, because every time they come and we are
not
ready with the
just-
matter.
Not just the jurisdiction of DGGI, the issue also
Kindly
involves
take to the
whether-
prayer, my lord. Kindly take to the prayer that they have made. Kindly see the prayer. Kindly see the prayer. What prayer they are making.
Issue also involves whether we are challenging the provisions relating to intermediary in case of 20.2 and valuation provisions relating to service tax under works contract in 20.01. So therefore, it is not just relating to DGJ jurisdiction itself, my lord. Therefore, this also should be tagged along or listed along with 75.
My lord, I have got my
So the issues
serious
are same.
objection to this. Kindly take to the prayer what they are making. Kindly take to their prayer. Contrary statement is made now after taking the interim order. Kindly take to the prayer. What prayer they are making. Kindly see the prayer, my lord. We have every jurisdiction to issue the show cause notice. It was heard at length, my lord, on the last hearing. Reddington judgment holds the field.
Kindly take up 20.1, my lord. I'm talking about.
But I can't hear it today.
My lords may fix a date, my lord. Your lordship may treat it as, my lord, heard in part or otherwise. Your lordship may fix a date at 2.
Yes, I'll fix a date. We'll fix
Your
a
lordship may have it at a specific hearing, my lord, so that for the last 5 years, my lord, the department is not in
We'll fix a date.
They took 4 years to file the objections.
No, that's okay.
When the matter is covered by judgment, my lord, they should not.
Serial number 20 lists the matter on
The same day as 75, my lord.
20, 20.1 and
on 6th.
my lord may have it
Same
at
day as
2:30 p.m.
75, because the issue one of the issues involved is the same as intermediary.
75 date per on 6th. List the matter in the same stage.
I am grateful.
On 6th of August.
Obligement.
Your lordship, I appear, your lordship, I kindly extend the stay, your lordship.
It is the next date.
Your lordship, in the serial number 20, stay may be extended, your lordship.
Yes.
And my lord, it may also be recorded that on the set date, my lord, the matter would be taken up finally, my lord. Your lordship may kindly record that.
Yes.
Because my lord, finally, otherwise again this interim order keeps on continuing, my lord.
Extended till the next date.
It may be made clear that it will be heard on that day, my lord. No further, my lord.
Both sides to be ready on the next date.
I am grateful, my lord. I am grateful.
21.
Obliged.
For the
Obliged.
petition in this case, my lords.
Anyone may make a submission, my lord.
21.
I appear for the first respondent, and Mr.
Yes.
Sethi appears for 2 to 4. It is shown that 1 to 4.
By mistake, my lords.
Office to show the name of Land Council Akash B. Shetty for R2 to R4.
Yes. Please.
Right. What is this matter?
It is in so far as the SVL DRS amnesty scheme, my lords. Because,
No, pleadings are complete or?
my lord,
Yes,
it's
ma'am.
been completed.
Hmm.
It's been completed. Lords, the issue, my lords, it's been squarely covered by the order of the Honorable Apex Court, Apex Court, my lords. This is in so far as the amnesty scheme, my lords. A month period is been given, my lords, to comply with the conditions. If at all, my lords, if the payment is not been done within the due time, my lords, they are not entitled for any benefits under the scheme. This is the whole case about, my lords.
Now they're seeking beyond that 1 month.
My lords,
Now they're seeking
my
relief.
lords, there is a delay of about 3 months, my lords.
So let us see then. Let it come next week. We'll see.
My lords,
Let us see. Orders have to be passed. Relist the matter. Is date code, old matter. Date code. Same stage on 5th. Yes.
22.
Therefore, I am on instructions, I am making submission, my lords.
Yes.
And this is for 10th semester exam, that is, portal is open.
22.
Yes.
Yes, 10th semester, my lords, today the portal opened for exams, my lords, and the day, I think day before yesterday, my lords, your lordships have permitted them to release the results. And I am told that they have not yet released the results, and they have to now pay for.
Your lordship had passed the order day before yesterday to announce the results.
They have not. Yet.
That we have conveyed to the university, my lord. I think so the results will be announced. The only question is that whether they could be permitted for the
Exam, 10th
teaching
semester.
examination, which is scheduled to be held on August 18th.
My lords, today is a portal opening for payment of fee.
No, that's okay. We'll have it on Monday. Let the new roster hear it. We'll have it on Monday.
Let them pay, my lords, subject to the result, any, as such, my lords, it is there.
That you file an IA, let the court consider, let the results be announced by then.
Please, please.
They
Results
have
must
not yet, they have not yet.
Correct. So we'll have it on Monday.
Please.
For whatever further relief, you file your application.
No,
file.
application is filed there.
Okay, let us see. Let the results come out first. By then, by the next day.
This is not given.
Relist the matter. We shall have it on Monday.
Please, please, madam.
On 29th.
Last
29th. Yes.
23 dismissed, 24. I mean, yes.
One, my lords. Sorry, apologies for interference, my lords. My interim order may be extended.
21. 21. Yes.
24, Naveen GS.
Lords, I appear for the petitioner, my lords. My lords, it's an order, petition challenging DRC 7 order passed by the second respondent, my lords. My lords, my preliminary objection in the reply that has filed to show cause notice issued by the respondent number 2 is that Rule 142 of the GST rules has not been complied with. Because it states, my lords, kindly, my lords, Rule 142 may be seen.
What is the matter?
Matter challenging, my lords, order passed under DRC 7, my lords.
DRC 7 is?
Copies are yet to be served.
Serve copy, serve copy.
Served.
Copies.
29/2/2024.
Then Council Shri Shamant Naik accepts notice for the.
It's already notice has been issued.
Notice has been issued, my lord, but copies are yet to be served.
No, now
Notice
you
was
accept
issued on
notice.
29/2.
Correct. You accept notice for respondent 1 and 2. Just give him the cost item. Page 5.
It's 1 and 2 is.
1/2, my lord, yes.
Then Council Shamant Naik accepts notice for respondent 1 and 2. The emergent notice to respondents 3 to 8.
Yes, ma'am. But I'm seeking for a stay of annexure because the order is passed and if they take coercive steps, it becomes infructuous. I'm raising the preliminary ground as to the
No,
non-compliant.
let him have a look at it. Let him have a look at it. You serve copies.
Kindly, my lords.
Relist the matter next week. Yes, next.
25.
Date may be fixed, my lords.
It will come next week. It will come next week.
Kindly, my lords.
Yes.
Got it fine?
For the petition. Issue pertains to year 2015-16, my lord. It's the second round of
2015?
16, my lord.
Yes.
The second round of litigation, my lord, actually. Once the matter was contested on the, based on the merits, my lords. Meanwhile, it has reached till the level of tribunal, income tax tribunal. Income tax tribunal reverted the matter back to the assessing officer, my lord. Now the AO has passed an adjudication, I mean to say assessment order without providing adequate opportunity to me to represent the case. The entire proceedings has been concluded within a span of 2 months as such. Meanwhile, at the last date of hearing, in response to the show cause notice, we have requested for an adjournment. It was denied. It was neither denied nor it's been considered. The adjudication, I mean to say, the assessment order has been passed, ex parte order.
My lords, it's an ex parte order, my lords, but your lordships at page number 41. Lordships, my lords, we've given number of opportunities, which, my lords, the only reason why I'm opposing for remand, this is the second round. And in the second round also, they have not appeared. And they've challenged this order now, again, your lordships. My lords, let them deposit, my lords, something, my lords, let them deposit 20%, my lords, we will redo it, my lords.
My lord,
Subject to certain conditions, my lords, your lordships, my
let me make one small submission. My lord, at first round of litigation, my lords, it's been contested on the based on the merits only, my lords. The matter has reached the tribunal. By the time the tribunal has directed us to produce some documents and evidences. Kindly look at page number 32 assessment.
No, but page number 41.
Please.
The table that is there indicates that response is not made out.
Please. Finally, my lords, at the show cause notice, the final show cause notice at 29/2/2024, my lord.
29?
To 2024,
yes.
We requested for an adjournment at Annexure F, my lord. Page number 39. I sought for an adjournment. Why? Because fund for cash flow statements and other financial documents has to be adduced from us. So that only we should have a conversation with, I mean to say, we should have a conversation with the tax consultant as such. That is why we have sought for the time. If the matter is remanded, we'll produce whatsoever been according to the observation of the tribunal. One opportunity.
May kindly consider to keep them on certain condition, let them pre-deposit, my lords. Otherwise, if it is a genuine case, my lords, I would not have opposed. Once we've given a number of opportunities, and in the second round also that.
My lord, it's with regarding to the similar matter which lordship has decided today, the fourth matter, man. It is also regarding the deposits of cash asset. He is also running.
Correct, they're saying that you are not diligent, so at least you shell out some percentage, then then at least more
difficult
interest will be shown.
My lord, he is into transportation and hotel business, hotel industries, my lord. Due to COVID, he is not into business anymore, my lord. He has suffered a lot, my lord. It will be difficult for him.
Allow it on some.
And it is an appealable order, my lords. It's not, my lords, this is an assessment order. After tribunal's direction, my lords, we passed an assessment. They can file an appeal against this order before commissioner appeals.
Due to violation of natural justice only, my lord.
Will impose costs, let him pay some costs. The petitioner has sought for setting aside of the ex parte order of assessment passed under section 144, read with section 254, read with section 144, capital B of the Income Tax Act for the assessment year 2015-16. In the case of the petitioner, that the authority during the course of the assessment proceedings on 29/2/2024 had issued a final show cause notice, and date of compliance was 5/3/2024, and due to certain bona fide reasons, and request was made for adjournment at annexure F on 5th March 2024, which was the last date of compliance made out in the show cause notice of 29/2/2024. It is submitted that in the assessment order, the assessing authority has not referred to the request of adjournment and matter is proceeded with and variation is made. On the basis of have a variation made and assessment concluded on the basis of best judgment assessment. Full stop. It is submitted that cash deposits of deposit of 59,06,448 has been taken to be an unexplained
Cash deposit.
What is that? Cash deposit is taken as? The cash deposit of 59,06,448 has been construed to be an unexplained income and brought to tax. Full stop. Then counsel for the petitioner submits that he would be in a position to demonstrate the source of deposit.
Unexplained cash credit.
Huh?
Unexplained cash credit.
Unexplained cash credit.
The section 68.
Under section 68.
Please.
Third counsel for the petitioner submits that if the matter is remanded, he would be in a position to explain the source of such deposit. Third counsel Shri Dilip, appearing for the respondents, vehemently opposes the remand of the matter back and submits that it is a second round of litigation and earlier opportunities afforded have not been availed of, and accordingly there is no ground made out to extend any indulgence to the petitioner. Next. Heard both sides. It's not in dispute as is made out from the details of opportunities given at para 2 of the assessment order at annexure G that the final show cause notice was made on 29/2/2024, fixing the date of compliance as 5/3/2024. It is a matter of record that the petitioner has sought for an adjournment as is evidenced at annexure F, which request was made on assessing officer has referred in the order that the SSC has slept over his rights. Full stop. Must be noticed that variation has been proposed and made on the premise that the petitioner is unable to explain the source of cash deposit. In light of the facts made out and also noticing the request for adjournment that was made, it would be appropriate to extend one last opportunity to the petitioner to make out his case before the authority. Accordingly, the order at annexure G is set aside, matters remitted back to the stage post show cause notice dated 29/2/2024. The petitioner to make out his reply within a period of
Lordships, may kindly leave it open, my lord, let them reply to the show cause notice.
faceless.
Leave faceless.
Faceless.
Make out his reply expeditiously, full stop. However, taking note that this is the second round of litigation and there has been some lapse on part of the petitioner in not adhering to the timeline for compliance, petitioner has to pay costs of rupees 10,000 to the respondent number
Respondent number 2, my lord.
respondent number 2.
Hello.
Accordingly,
My lords, which will not be adjusted against the demand, my lords. This 10,000 should not be adjusted against the
and
demand. your
such
lordships.
cost is not to be construed as amount paid towards any claim of the revenue. Full stop. The orders at annexure G and H are set aside and matter is G and H, isn't it?
Please.
Are set aside and matter is remitted as above.
My lord.
All contentions are kept open.
My lord, cost may be reduced.
Huh?
Cost may be reduced.
59 lakhs.
Please.
Huh?
Demand is
My lord,
20,
one more point, my lord. They have not issued draft
demand
assessment
is
order.
23 lakhs.
Huh?
26 lakhs.
They have not issued the draft assessment order also, my lord.
That will come after your reply, isn't it?
Please.
Huh?
They have to, we don't have, my lord, this draft order need not be passed in. It's only in the case of international taxation, my lords.
Faceless, draft assessment order has to be passed, my lord.
Let
That
us
is
see,
not
that
been-
procedure is kept up. I'm not going to comment.
No, here
Whatever
also, my lord, that is not been followed, my lord. So if at all, if they have passed an order, I would have got one more opportunity to adduce my argument.
The draft order is not required to be followed.
No, anyhow, in the stage of reply,
Please,
all
Manoj.
contentions are kept open. You make your stand.
Cost may be reconsidered.
No, it's a small amount for a big sum. It's okay, you pay.
Please kindly 5,000. 5,000.
No, you pay 10,000, is reasonable.
26.
High Court will also have to maintain some standards.
Please.
My lords, appeal for Krishna Bank, my
Yes.
lords. My lords, this is a case, my lords, where a asset, where a immovable property which has been mortgaged, my lords, in favor of the bank has been attached under.
My lords, they've not served the copy, my lords.
You serve a copy on Dilip.
I'll serve, my lords. It's covered, my lords, by the judgment of Madras High Court, Andhra Pradesh High Court, and Supreme Court.
Correct, but you serve a copy, we'll have it.
I'll serve, my lords, I'll serve.
Copy to be served on learned counsel. and
There is
Dilip.
a private respondent, my lords, respondent number, notice has to go to him.
Notice may be dismissed, my lords. He is a borrower, he is not contesting or anything. my
That
lords.
is his properties we have attached.
R3 at the
Already
risk of
sales
the
certificate is
petitioner.
issued.
At the risk of the petitioner.
Yes, my
It
lords,
is the
because sales
matter
certificate is already
next week.
issued
Yes.
by the bank.
Obliged.
Much obliged.
27. 27.
Yes. Yes.
Lordship, there is a demand of ITC on the ground of difference between GSTR 2A and 2B, Lordship.
Third counsel Shamant Naik accepts notice for the respondent.
Yes. But here, order has been passed under 73. Then after that, my lord, he's preferred an appeal. Appeal has got dismissed on the ground of delay. Now, my lord, he approaches this court, my lord.
Appeal is dismissed on the ground of
Dismissed on delay. That is not challenged. That order is not challenged.
Is a 3 days time was the circular was there, which your lordships also passed an order, where in cases even appeals were not filed, your lordship, on the ground that the assessing officer should have ought to have considered suo motu because 2018 and 1920 are covered in the circular. In the present case, your lordship, he appeared before the authority. Time of only 3 days was given, your lordship. Violated principles, lordship. Only 3 days time was given, and the documents pertain to 2017-18, more than 4 years. Now he has got, he is in possession of all the documents, lordship. Matter may be remanded, lordship. He is ready to deposit another 10%. He has already deposited 10% while filing appeal before the commission. He will deposit another 10%.
Lord, he's not even challenged the
No, he cannot.
appeal order, my lord.
No, you challenge it while considering how to mold relief the court may do, but you have to challenge it.
Only thing is, if I challenge it for not GST tribunal, lordship now. No GST tribunal, lordship, not functional.
No, you challenge it in the present.
I filed appeal, lordship. I challenge it. Appeal was belatedly filed. It's a proper.
That order of dismissal, you challenge in the present proceedings,
True.
and then we'll more relief appropriate.
I will amend the petition motion. Shall I
Hmm.
amend?
Relist the matter next week at request.
28.
Yes.
Petitioner has filed a memo for withdrawal of the petition. my
Learned
lord.
counsel for the petitioner has filed a memo for withdrawal, which reads as hereunder. In light of the same, which reads as hereunder.
May I make a submission, my lord?
Petition is dismissed. Yes.
29.
He may be given liberty, my lords, to file a appeal, my lords, by condoning the delay if there is any, my lords.
Now, against that order, you have a right of appeal.
Yes, my lords. The writ petition was filed well within the time, my lords.
Within the time.
Yes, my lords.
The order dated
5/2/2024, my lords.
And appeal is to be filed within
90 days. Within 4 months, my lords.
within 4 months.
Yes. It was filed on 1st of June 2024, my lords.
So the order is 5/2/24.
Filed on 1/6/2024.
So the time is 120 days.
90 plus 30, 120
90
days.
plus 30 ಅಲ್ಲ 90 plus 30 107
Within 4.
Within the
Within
time.
4 months.
ಅವನ್ನ ತಗೊಂಡೋಗಿದ್ದೀನಿ.
Yes.
Just verify this. What's my password 230 or this?
No, this,
See on this time,
the date of filing is 1/6/24.
120. Yes, my lords.
1/6/24. Order at annexure E
Extended time there.
is
5/2/2024.
5/2/24.
3 plus 1, 4 months.
4 months.
ಆಗ್ಲಿ. Yes, sir. 4 months.
The counsel for the petitioner has filed a memo seeking withdrawal of the petition. Full stop. It is submitted that liberty may be, the learned counsel for the petitioner makes a submission that liberty may be reserved to challenge the impugned order dated 5/2/2024 at annexure E by way of appeal. Full stop. It is noticed that the challenge to the order at annexure E was made by filing of the writ petition on 1st June 2024 within the time permissible for condonation.
Condonation. Yes, my lord.
Full stop. In light of the same, petition is dismissed as withdrawn. All contentions are kept open. If the appeal is filed within a period of
1 week, my lords.
1 week, the same may be taken on
2 weeks, my lords. I'm sorry, my lord. 2 weeks.
within 2 weeks, same may be taken on record without raising any objection on limitation, as the petition itself was filed within the period of limitation.
Much obliged.
29.
You can file one different memo. You have not sought for. You have not sought for any liberty. So you can file one memo, handwritten memo, seeking liberty and making a mention that petition itself was filed. Will do that. Yes.
Third copies on criminalization. There's a case, my lords, where I have challenged 148 AB notice and 148.
Mike. Yes.
The petitioner, my lords, is a regular assessee. A return of income was filed within the statutory time of 130.
You can hear, Tirumalesh, you can hear him?
Yes.
Yes.
Notice under 148 AB is issued as to deposits made in the bank, my lords, during the demonetization period. I filed a reply, my lords. My return of income filed is at page 16, my lords, annexure A.
It's filed on 14/9/2017.
On?
14/9/2017, my lords.
Yes.
And I have maintained regular books of accounts which are audited, and I have enclosed the audit report also obtained. It starts at 24 onwards, my lords, page 24 onwards of Annexure A. Now, I am issued an 148 AB notice, my lords. It's at page 34, Annexure C. The reason is cash deposits and purchase and sale of edible oil from one particular person, my lords. I made out a reply, my lords, on 11/4/24. This is dated 27/3/24, my lords. In the reply, my lords, I have given him the full details of my sources, including the cash book I gave him. And a order is passed under 148 AD.
Yes.
It's at page 154, Annexure E, my lords. Para number 5, my lords, in that. Bottom 4 lines. Bottom 3 lines, my lords. Further, as seen from the details of cash deposits made by the assessee in para number 4 of his reply, that the cash deposits made were more than the cash sales made during the corresponding month, which requires further verification. This is not permissible under the Act, my lord. Because 148A itself is issued after verification. And I have furnished the cash book itself, my lords. Copy of the cash book is furnished.
Yes.
And a notice is issued under 148. It's at page 157 by the jurisdictional assessing authority. I am challenging this notice, my lords, because under 151A, my lords.
Yes.
It has to be under the faceless. I rely on this Bombay High Court judgment. And similar petitions have been admitted, my lords, questioning the faceless notice issued by the jurisdictional assessing authority.
Let us see, Tirumalesh will state, we'll see. Now, Bombay High Court has addressed this very same issue. It requires some adjudication on that legal question. In light of the contention that notice under 148
Yes, my lords.
has been issued by jurisdictional assessing officer without following procedure under the faceless assessment scheme. And as counsel for the petitioner relies on the order of the High Court of Judicature at Bombay in WP 18458 of 2024, there would be stay of
Annexure F, my lords.
Annexure F. The respondents are at liberty to seek for modification of the interim order upon filing statement of objections. Now, Counsel Tirumalesh accepts notice for the respondent. Yes.
30, Vikram.
But this is a case where my lordship was pleased to issue an interim order staying Annexure K order, my lord.
Yes.
While the interim order was in force, my lord, the respondent authorities proceeded to initiate recovery proceedings and debited the tax amount from an electronic credit ledger. Now, my lord, I have filed an IA, my lord, seeking for a direction to reverse the amount, my lord.
There seems to be some communication gap, my lords. My lords could kindly have it Tuesday or Wednesday, my lords, I'll get instructions. There was an interim order. Probably what has happened, according to the instructions I received now, the interim order was communicated on 3rd by around 11 o'clock in the morning. But the amounts were recovered on 3rd morning by 10:30. However, my learned friend brought to my notice that they had sent a mail on 2nd evening also. I'll just cross verify with the officer. My lords may have it on Tuesday or Wednesday, my lords.
My lord, we have approached the officer on first, my lord.
Correct, now.
Let's-
now-
I'll,
now they
Used to-
accept there's a lapse, they'll rectify it is what they.
no, I'll just get the instructions as to how this happened.
Relist the matter on,
Wednesday, my lords.
yes, 31st.
Serial number 31, Amurthy.
Give me a copy of that. Unfairly.
Also a petition against the 148 AB and 148 and subsequent assessment order. SC is not an SSC. He had made some investment, my lords, in purchase of property along with 4 others, his brothers. Entire thing is proposed to be assessed in the name of the SSC, but ultimately assessment is made on the 1/4 share of the assessment, my lords. My submission, my lords, is that the investment is made. 1 crore of investment by 4 brothers, my lords, were made in the earlier previous year, which cannot be subject matter of this particular assessment year, my lords. And then the current assessment notice issued for assessment year.
Yes.
16-17.
They've not submitted any response before the officers, my lords. Let the matter go back to 148 AB, my lords.
And I have also raised the 148 notice issued by the jurisdictional.
That we'll see, let it go back, we'll see, you make out a reply. On merits, you get a relief, there ends the matter. The petitioner. That 148 and faceless, you will have to resolve that.
Now, my lords, the finance bill is completely substituted as new section, my lords.
Is it?
It's changed, my lords.
That's the amendment made.
Yesterday, my lords. Finance bill, but we'll see, my lords.
Coming to effect.
But earlier notices will not get.
And there's no longer 148 AB, AD, nothing of that nature, my lords.
So it reverts back to the earlier system.
The petitioner has sought for issuance of writ of certiorari to set aside the notices under 148 capital A small b at annexure B and B1, as well as to set aside the order under section 148 capital A small d at annexure C. Petitioner has assailed 148 notice at annexure D and the assessment order under 147 read with section 144 of the Act at annexure E. It is the case of the petitioner that he was not a SSC and hence had no knowledge of notice that was uploaded on the basis of the petitioner's PAN.
And it was sent to the address of the chartered accountant, my lords.
Full stop. It's further submitted that the petitioner had no notice even otherwise, as notice was sent to the
chartered accountant
address of the chartered accountant.
Yes, it states it is sent Nilakante Gowda, chartered accountant Kolar, but he is resident of Mudbagan.
Page?
I have made at
43 also, my lords, page 43.
no, the averments is made at page 4, my lords, para 4 of my petition. And sent by post by stating the address as that of chartered accountant at Kolar.
It is further submitted that notice was sent to the address of the chartered accountant at Kolar. It was not communicated to the petitioner.
It was not.
Good stuff. It is next. Further submitted that the petitioner would be in a position to meet the demand. If an opportunity, position to explain and clarify as regards the demand raised. If an opportunity is provided. The order under 148A(D) has been passed, observing that SSC has failed to disclose nature and source of purchase of immovable property. Understand? It is the contention of the SSC. What is your contention?
No, he is an agriculturist, my lords. The property was bought by 4 persons. He along with his other 3 brothers. 1 crore was made in the earlier year, not relating to this particular. And they had raised a loan of 1.5 crore and balance was met out of the agricultural income proceeds.
So the sale consideration is 4 people.
Yes, it is 4 crores, my lords.
It is learned counsel for the petitioner would submit that the sale deed as regards sale of the immovable property was by 4 vendors.
No, purchase it by 4 persons, my lords. What is,
You are the purchaser or
I
seller?
am the purchaser, my lords.
The sale deed as regards to the property. A sentence in the I would submit that the purchase of the immovable property was made by a sale deed wherein apart from the petitioner, there were 3 other purchasers.
Yes, my lords. Sale deed is at annexure A, my lords. Page 13.
Such aspect has not been taken note of appropriately. Noticing that the 148(A)(D) order has been passed without any explanation on record by the petitioner herein. And noticing the petitioner's contention that there was no service of notice to the petitioner as he was not a SSC previously, it would meet the ends of justice by relegating the petitioner to the stage of reply to 148(A) notice. Accordingly, the order at annexure C is set aside and consequently 148 notice at annexure D and assessment order at annexure E are set aside. Matters relegated to the stage referred to above. All contentions are kept open.
Thirty-two also similar matter. Here the assessee is a rice dealer.
They have not replied to 148(A)(B), madam. 148(A)(D) order and assessment order also is passed, madam. Lordships may kindly tell them file reply to 148(A)(B) notice.
Yes.
Similar, identical. Only thing is here he is a rice dealer, my lords. He used to procure the rice locally and sell it to the others. And whatever the proceeds of sale of rice was deposited into the OD account with a cooperative bank. That the deposits are treated as income, my lords.
The petitioner has challenged the notice under 148 capital A small b at annexure B, comma, 148 capital A small d order at annexure C, comma, notice under 148 at annexure D and the order of assessment at annexure E. And demand notice at full stop. It is submitted that the notice was merely uploaded on the e-portal, which petitioner was not aware of. Full stop. It is submitted that the petitioner is in a position to explain that the cash deposit relates to sale of rice, and as the income was below the taxable limit, no return was filed. Accordingly, an opportunity to make out reply to 148 capital A small b notice is sought for. In the order under 148 capital A small d at annexure
C, my lord, page
C,
20.
the authority has observed, the officer has observed the deposits made by the SSC in the bank not having been explained, and in the absence of return of income, the matter requires to be proceeded further by reopening the requires to be proceeded further. Full stop. Next. Taking note of the submission of the petitioner regarding non-service of notice, and that petitioner is in a position to explain the source of deposit made as relating to certain sale transactions. Matter could be disposed of by relegating the petitioner to the stage of 148 capital A small b notice. Accordingly, the order at annexure C, notice at annexure D, order at annexure E, and demand notice at annexure F are set aside. Matters remitted to the stage of reply to the notice under 148 capital A small b. All contentions are kept open. Accordingly, petition is disposed of.
Public.
Kindly, ma'am. Serial number 51, 52, and A, ma'am. These are matters which will have to go back before the adjudicating authority.
At 2:30, you make a mention.
I have some inconvenience in the afternoon. My lords could have it tomorrow morning.
Tomorrow.
Oh, pleasure.
My lord,
Fresh matter list.
Uh,
51, 52, 53.
ನಾಳೆ
ಬೆಳಿಗ್ಗೆ ಸೇಮ್ ನಿಮ್ದೆ ಬ್ಯಾಚ್
All yours, man.
2:30.
final again.
Make a mention.
Yes.
Serial number 58, 61, 62, and 65. I will take it to Friday. Can be posted in order ships. Either listed for
Friday.
disposal ex parte orders.
But Friday it may not reach.
Order ships.
Last day, so I've got some other work. It may not reach on Friday. That is my predicament.
Journalists can give it next week, but can
Unless-
it be posted in orders?
Unless you retain me here.
Most,
Huh?
usually what you hear.
List matters next week. 58.
58, 61, 62, and 65. In orders, please.
Yes, in orders list.
And one more matter, 66, that stay has been granted. I will take a regular date after 2 weeks.
Yes.
Obliged.
60,
66.
66. List after 2 weeks.
Obliged.
Interim order earlier grant is extended till next. Yes.
Lordship, serial number 78. I would be waiting for my turn. It was at 2:30, my lords.
Yes, madam. Yes, we'll take
I
it.
will wait. I would wait, my lord, obliged.
46, there is some urgency.
Serial number 46.
ಇವಾಗ ಎಲ್ಲಿದ್ದೀವಿ? ಇವಾಗ ಎಲ್ಲಿದ್ದೀವಿ? We'll take it up, just. Lady ಇದು 4 ಗಂಟೆಗೆ ಅಂತ ಹೇಳಿ ಕೂಗ್ಬೇಡ. ಒಂದ್ಸಲಿ ಕೂಗ್ಬೇಡ. We'll take up 78 at 4 o'clock, madam. I'll run through my remaining list. I'll take it up at 4 o'clock.
Obliged, my lords, I'll wait.
Yes.
Further hearing, 77. Serial number 77. Vijayant Babu.
How much time will take, Mr. Babu? Roughly. So we'll take it up on, anyhow it's part heard. So we'll take it up on some other, last 2 days we have some other emergent matter. So I'll take it up and continue after, in my new roster, depending on where, we'll take it up. Heard in part. Due to paucity of time, matter could not be taken up. Matter is adjourned.
Lord, serial number 77.30. Rita's, my name may be shown.
77.30.
I appear for the petition.
Office to show the 77.30. Office to show the name of Land Council Arvind Chavan.
Please.
Representing R1 and R2. And delete the name of Land Council Preeta M. Yes. Interim order, otherly 77 interim orders in operation are extended till the next date.
My lords, in serial number 77.
Yes.
One case, my lords, interim order is not granted, recent matter. It may kindly be granted in that, my lords, because service tax authorities, they are calling upon the petitioner.
77 point.
My lords, 6979 of 2024. 6979 of 2024.
77.42. In light of interim orders granted in other matters raising identical issue, there would be an interim order of stay of
Annexure K.
Annexure K till the next date.
My lords, K and S.
K and S. Yes.
Much obliged.
77.
I've adjourned it. Anyhow, it's heard in part. I'll resume it in my next roast.
Okay.
In one matter, there was no interim order because in other matters we have granted it.
No problem. Similarly.
34. Next minute. 34.
Today it won't reach, madam. We'll have it next week. We'll take a chance.
Next week, my lord, because this matter is arises out of 26 AS only, my lord, and order in appeal, they have filed belatedly by 112 days. So that is the issue.
We'll release the matter next week.
Next week or week after next also.
Week after next.
35.
Yes.
35.
Appearing for the petitioner in this matter, my lord, serial number 35.
35.
Appearing for the petitioner, serial number 35, my lords.
I require a week's time, my lord, in this. Require a week's time in this, my lord.
My lords, on the earlier occasion also time was sought. Lordship may appreciate that the only issue involved in this writ petition is the challenge to the order of cancellation of registration, wherein show cause notice was issued at a time when the petitioner was under judicial custody. When the matter was presented before your lordship on the last occasion, your lordship opined that the matter can be decided on the basis of SCN itself.
No, correct, but let us see some instruction, otherwise, let's see what they say.
Some criminal proceedings are initiated in this. I'll have to just get some instructions on it.
My lord, the criminal proceedings may take time, my lord, but be that as it may, the legality of the show cause notice is all that is to be decided, my lord. Lordship may just have a look at it for.
No, let us see, they have some instruction, let him complete it, we'll have it next week.
Great.
That
My
request.
lord may kindly grant a date. And also there was one CK indulgence, my lord, there was some confusion on the nature of respondent because the order is passed by LGSTO, whereas the name of superintendent is also written over there. So an experience.
Relist the matter on date.
My lord, the respondent may clarify whether if he is answering respondent or not.
My lord, they were trying to clarify whether the central government is the adjudicating authority or not. I'm yet to receive instructions on that. Last date I had taken notices.
Relist the matter on 6th.
Great.
Obliged, my lords.
36.
My lords, in serial number 36, my lords, there are three issues that arise for consideration. On the earlier occasion, my lords, when the argument was presented on preliminary basis, it was submitted that the show cause notice was issued under section 73 subsection 1 and no personal hearing was granted, to which your lordship sought to for an answer from my side whether personal hearing is mandatory. My lords, the answer lies in section 75.
Section 70?
So, section 75, subsection
Yes.
4. Section 73 and 74, as the lordships are aware, is the provisions for determination of tax and recovery. 75 provides for general provisions relating to determination of tax. May I read, my lords?
75 subclass
4, my lords. May I read, my lords? An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. In this show cause notice is admittedly issued, my lords, proposing to levy tax on me. And the show cause notice DRC 01 clearly mentions details of personal hearing nil. And within 15 days of issue of show cause notice, order is passed. Show cause notice is issued on 30th of December 2023 at page 60, my lords.
Page
60 is the show cause notice dated 13th of December 2023. And the lordship may for a moment take to page 65. That's the summary of show cause notice. It starts at 64 and at 65, the details are given, my lords. Lordship are with me at 65, my lords?
Yes.
In the table at the bottom, description particulars. Date of personal hearing, NA, not applicable. Date of personal time of personal hearing, not applicable. Venue where personal hearing will be held, not applicable. And there is no personal hearing in this case. And order is passed, which is at page 66, next page. This itself vitiates, my lord, in the light of the express statutory provision that personal hearing is to be, that opportunity of hearing is to be granted. And in the absence of personal hearing, this vitiates section 75 subsection 4. My colleague in the court, I hope he has reached the court, I'm sorry, my lords, I will hand over two judgments, one of Gujarat High Court and another of Madhya Pradesh High Court, which have interpreted section 75 subsection 4 and have held that opportunity of hearing contemplated under section 75 subsection 4 would mean personal hearing.
Yes.
That is my first line of grievance, my lord.
No, just 1 minute. Now you have to complete your instructions.
I'll have to complete my I'll have to complete.
In light of this submission by counsel for the petitioner that the assessment proceedings are concluded without affording an opportunity of hearing, which is a statutory mandate in terms of section 75(4) of the CGST Act, and noticing that GST DRC 1.
Yes, sir.
Which observes that personal hearing, which indicates personal hearing was not afforded. There would be stay of
My lord, stay of J1, my lords.
stay of annexure J1.
J1, my lords.
Respondents are at liberty to seek for modification of the interim order upon completing their instructions.
My lords, my grievance doesn't end here. I seek your lordship's indulgence. My grievance of the second order is that upon the passing of order, recovery is already made within the period of 90 days. I had maintained balance in electronic credit ledger and cash ledger for the purpose of meeting the GST liability for the month of, in the regular course, GST liability for the month of March onwards. However, due to recovery being made on 11th of March, before I could even file my monthly return for the month of February, I was left with no funds. As a result, I could not make the GST monthly payment and I could not file my monthly return. Now my monthly return is pending for the last 4 months, my lord, because of this adverse action of the respondent. Therefore, I may be protected in this case. And the lordships have already passed several orders which have held that recovery before 3 months is impermissible. An interim direction may be given to refund that money recovered illegally, my lords.
Let him find out. We'll have it.
Notice
next week.
not it.
Let him find out. Let him find
I was
out.
just trying to point out the urgency, my lord. That's it.
Yes, let him. I'll have it next week.
Please, my
This
lords.
is the matter next
Weeks, my lord. 2 weeks.
Lordship may kindly give a date.
week after next date. 12.
Hopeless, my lords.
57, Nil Kumar, please.
May I please, Miller? I'm appearing for 37.
Yes.
Milord, I'm extremely grateful to my learned friend, Milord, who just showed a few judgments, Milord. Even I have on 75-4. Milord, my case is identical, or Milord, I should say similar, except that, Milord, Annexure A order was passed, Milord, without granting the mandatory personal hearing. Milord, instead of coming to this court, Milord, directly and then, Milord, filing a writ petition, Milord, my client had, Milord, filed an application under 161, my lord, asking for rectification. Well, that was also, my lord, while Annexure B, well, that was also disposed of. Admittedly, my lord, no hearing was given. My lord, your lordship may kindly see page 24, Annexure A. That's the order, my lord, assessment order. No hearing was given. It only refers to, my lord, DRC 01A and 01. And, my lord, without granting any hearing and without considering any of the submissions, Lord, I'm not going to the merits at all for the time being because my bank account has been attached, my lord. Therefore, my lord, I'll be grateful if your lordship could grant me a stay and release the bank attachment so that, my lord, I will argue on merits also, my lord, if required, and, my lord, on the next day. Your lordship may kindly see, my lord, my Annexure A was passed without granting hearing. My lord, that's an admitted fact. Page 24. Then, my lord, instead of filing a writ petition, I filed an application for rectification. And, my lord, in page 41, Annexure B, kindly, my lord, see Annexure B, page 41. Well, they disposed of my rectification application, my lord, in 2 pages, where, my lord, they've stated that everything has been considered. Therefore, my lord, it is not required to interfere. So this is also, my lord, in violation of principles because they gave a hearing, they took all my submissions. No order on merits has been passed. But the primary fundamental flaw, my lord, this Annexure A, page 24 order, my lord, that was passed in violation of principles of natural justice. So therefore, my lord, I'm seeking stay of this order. And, my lord, by page 41 Annexure B order, my lord, no harm will be done except that, my lord, it has been rejected. So if your lordship may only kindly grant, my lord, stay of this Annexure A order and, my lord, release my bank attachment, my lord, and fix a date, my lord, I'll be grateful.
We may have this next week, my lord. No instructions received.
Let us see.
Bank attachment.
He'll respond by next week. He's going to.
No, my lord, this has come for the 4th day, my lord, because I'm from Chennai. That's why, my lord, I couldn't come in person. My lord, this bank account has been at, my lord, 65 crores, my lord, has been attached since May 2024. Lordship may kindly see page 24 for a minute. My lord, there's nothing at all. I thought, my lord, my learned friend is not going to agitate that fact because no hearing has been given. That's, my lord, crystal clear. Then, my lord, page 41 order. The only difference is, my lord, I went for the second round through an ROM, which, my lord, I ought not to have done. I probably could have come here directly. Then, my lord, this court would have probably, my lord, interfered at that stage. Lordship may kindly see page 24. And, my lord, the order, my lord, starts at page 24 and page 39, my lord, it ends.
it only talks about in page 39, reply to show cause notice and my lord, the quantification. There is nothing at all, my lord, no hearing was given. And they admit that, my lord, in page 41, they're saying, my lord, that there's no requirement for personal hearing. And they said that, my lord, everything has been considered at the audit stage itself. So therefore, my lord, that it is clear that no hearing was granted at the stage of passing of the assessment order for the year 2017-18, my lord, on 22/12/2023. I'm not able to, my lord, conduct any business, my lord, complete standstill. The impugned order runs to several pages, but only one objection, my lord, relating to, my lord, the number of contracts, the clubbing of contracts, my lord, the issue on merits. I'm not getting into that at all because the paucity of time, my lord, for lordships. That's why I'm only requesting a lordship to look at the violation of this alone, and then, my lord, to grant me an order of interim stay.
What is your contention on merits?
My lord, on merits, my lord, the matter is even simpler. My lord, I entered into 4 different contracts. My lord, the 4 contracts, my lord, one for supply of solar module. Then, my lord, the second contract is with reference to, my lord, erection, testing and commissioning. Then, my lord, civil works is the third contract. Then 4th contract is engineering, procurement and construction. My lord, on the first contract, I have discharged GST at the rate of 5% on the supply module, which is admittedly, my lord, the rate is proper, perfect. Then for the rest of the 3 contracts, I had paid 18% GST as service contract, my lord, works contract. There is also no dispute on that. All these contracts were entered into on September 2017. Well, now what the officer says, he looks at some bidding document in March 2017, anterior, prior to, my lord, the awarding of contracts. And then he says this entire solar power project is one single contract. You have bifurcated that into 4 contracts by trying to avoid, my lord, payment of GST. But I said that there are 4 contracts. 4 contracts are separately awarded, payments are separately made, and therefore, my lord, these have to be, my lord, treated separately. Therefore, my lord, there's no question of clubbing these contracts at all. So he says I have artificially vivisected. Well, if there is a single contract, I vivisect and then start paying taxes, then, my lord, he can accuse me of artificial vivisection. What I have done is, my lord, there are 4 contracts, I have paid taxes correctly on all those 4 contracts. So he is trying to artificially club, for which, my lord, there is no power at all. And, my lord, he invokes the definition of the works contract and then says that it is liable to tax on the entire contract. Well, if your lordship sees the definition of works contract under section 2119, well, it only says a contract, how it should be treated, a contract. It uses the word a contract, how it should be treated. There is no power for the, my lord, GST authorities to club for contract under works contract. All they need to do is, my lord, look at mixed supply versus composite supply. If you look at, my lord, if the authorities were to look at that concept of mixed supply versus composite supply, well, then mine will fall under composite supply. The predominant intention is only supply. Therefore, my lord, the supply will take precedence over the installation erection, and that 5% will not be applied for the rest of the other 3 contracts. On the contrary, my lord, I paid the entire 18% on all those service contracts. On the single contract for supply, my lord, I have paid 5%, which is normal. Now they want, my lord, 18% for the, by clubbing all the 4, they want 18% all of that, my lord, which is, my lord, completely impermissible. I will demonstrate that, my lord, with your lordships kindly see that this cannot be done for the simple reason that, my lord, there is a definition of works contract that, my lord, alone, if your lordship sees, because their entire argument, my lord, is saying that it is works contract, therefore, my lord, it will fall under that 18%. My lord, if your lordship sees, my lord, for a minute, if your lordship sees section 2119. Well, that is the definition of works contract, under which or based upon which, my lord, they want to say contracts could be clubbed and, my lord, a higher rate of tax could be demanded. My lordship may kindly see 2119, section 2119.
Yes.
May read, my lord, works contract means a contract. My lord, kindly note, my lord, a contract. So it can only examine one contract at a time. A contract for building, construction, fabrication, completion, erection, installation, fitting out, improvement, modification, repair, maintenance, renovation, alteration, commissioning of any immovable property, wherein the transfer of property in goods, whether or as goods or in some other form, is involved in the execution of such works contract. Well, this does not give them power to club contracts. It talks about a contract. So I have entered into admittedly 4 different separate standalone contracts. So each of those contracts should have to be examined. They have to see whether that's a works contract or not. If so examined, they will have to come to the conclusion that the contract number 2, 3, and 4 are works contract on which I have paid 18% correctly. Contract 1 is a pure, simple supply contract on which I have paid 5%. So they can't even examine my first contract under Millard works contract. They are saying, using this definition of works contract, well, now they want to say that it is nothing but 4 contracts. I have artificially vivisected. Well, there is no question of my vivisecting at all. I can't vivisect at all. Now, if your lordship kindly see, my lord, their finding, which is very short, in page 29, as regards this, they want to apply to section 2119 to my case. I would only demonstrate how patently inapplicable this particular provision is. Page 29, well, that is the finding given in the previous page. Well, it says conclusion of audit. Your lordship sees page 29, para number 2, where it says, in the light of above facts, this office would like to observe that the definition of works contract as provided in section 2119 of the Act, it defines works contract as a contract. Well, so, whether or not, well, next to 4 lines, which I read to your lordship. Finally come to Millard, 6th line. The contract is for engineering, procurement, commissioning of the solar power generating system. What is transferred to the entire power generating system, including the civil works involved in the project. So this is actually, it is perverse because they are saying the contract is for engineering, procurement, so many activities. There is no one contract. Your lordship, may kindly see the previous page, my lord. Just the previous page, page 28. The authority has listed out what are these individual contracts. Your lordship, may kindly see page 28, page, the top of the page, that is contract number 1, supply of equipment materials. Then your lordship, may skip the 5 lines and kindly come to Roman small 2, erection installation, that's a separate contract. Then civil works, that's another separate contract. Then engineering procurement contract. Then the 3 lines over there below, that is the crucial one. It says the company would like to state it had
Page
entered
39.
into.
Just 1 minute, just 1 minute.
Page 39, 3rd paragraph. After receipt of the show cause notice.
Page 39.
3rd paragraph.
Yes.
After receipt of show cause notice, taxpayer has not filed any objections till date to the discrepancies raised in the show cause notice dated 25/9/2023. This shows that no objection has been filed. He hasn't opted, my lord. He has to at least write a letter to us saying that he wants a personal hearing. Or, my lord, on the online portal, there is an option, my lord, whether to tick whether he wants to be heard or not. Now, when he doesn't respond at all, then he says that he is deprived of the right to hearing.
But you have not filed your objections to the show cause notice.
My lord, I have already given to ADT, which has been discussed in detail. But after the issue of
That is a
DRC 01,
Lord,
that
he
is
has
what my lord, my learned friend said. If an adverse order is contemplated against me under section 75(4), it is mandatory for them to give the personal hearing because 22/12 they passed the order. If your lordship sees, my lord, the DRC 01, my lord, which is in page number, my lord, page number 56. Lordship, may kindly see page 56, my lord. DRC 01 was issued on 25/9. Between 25/9 and between 22/12/2023, the authority ought to have given me a personal hearing. If they do not have, if they have not given, which is, my lord, direct violation of 75(4). Kindly see Annexure D, page 56, my lord. That is a show cause notice in form DRC 01, which is dated 25/9/2023. After issue of notice, they must wait for my reply. If I do not reply, they have to give me a personal hearing 3 times. That has not been given. That has not been given. They passed an order, my lord, on 22/12/2023.
3 months time. 3 months time has been given. From the
My lord,
date
they
of
have not
so-called
given me any
notice,
hearing. They should have given one hearing.
you have to,
If I don't,
they have to, my lord, opt for it online.
no, my lord,
There is
that
an
is the.
option there.
Well,
That has not been produced here.
Well, that is
But,
completely incorrect. 74, I have number of case laws. Whether you do ask,
Just
whether
one
you do
minute.
not ask,
Just
it is
1 minute.
mandatory.
Just 1 minute.
Yes, my lord.
Under 75(4), there
Yes,
are
my
two
lord.
parts.
yes, my lord.
One part says you have to request.
Yes.
The second part says that in case there are adverse consequences, then you must afford. So that means even whether you ask or not. First part is you can ask. Second part is if you are going to impose any adverse consequence, then you have to afford. Now, his argument is after 25/9/23, suppose you are going to dispose it off by imposing any adverse consequences on him, then you have to afford an opportunity of hearing whether he asks or not. That appears to be the content.
Waited for 3 months for it.
No, correct, but then you will have to afford
I understand.
the in light of the contention of the petitioner that during the course of the assessment proceedings, after the notice dated 25/9/2023, the authorities have concluded the proceedings without affording an opportunity of hearing as contemplated in the under section 75 subclause 4 full stop. It is admitted that the second part of section 75(4) would require affording opportunity of personal hearing where adverse consequences are sought to be inflicted upon the SSC. In light of such contention, matter requires consideration. There will be stay of
Lord, Annexure A, my lord, and Annexure, my lord, D. I'm sorry, B, my lord.
Annexure A and Annexure B till the next date. Respondents are at liberty to seek for modification of the order upon completion of instructions.
Lord, my bank attachment, my lord, may be lifted.
Yes.
My bank attachment, my lord, they've attached my entire bank account, my lord. I'm not able to operate.
Not at this stage. Not at this stage.
No, my lord, they've attached my bank account, my lord, without any notice. I don't even know, my lord, the bank writes to me. They are supposed to inform me, then, my lord, then proceed. My lord, I have not even completed because they passed the second order on March 2024. Within 3 months, my lord, I filed the writ petition. My lord, it's coming for the 4th time. In the meanwhile, my lord, they've attached the bank account. My bank, my lord, they are.
Let the matter be listed next week, my lord, for disposal.
Let us see. On this aspect, I'll keep it open. He wants to complete his instruction. I'll fix
Yes,
a
sir.
date.
Yes, sir.
Insofar as request for release of bank attachment, Learned Counsel for the Revenue submits, he would complete his instructions on such aspect. Relist the matter on 12th.
Great.
I'm grateful.
38.
If I may, my lords, I'm sorry to interrupt. Lordship are kind to give me interim order in the serial number 36. The annexure has to be B3 and not J1, my lords.
Annexure?
B3 and not J1.
B3.
The adjudication order at B3.
B for Bangalore.
B for Bangalore 3, B3.
B3.
Okay, my lords.
Yes.
38.
Also, I have looked to submit the question of taxability of deposit made, which is not utilized for rendering of service, is clear from the definition of consideration, and such deposit would stand excluded from the price of supply of goods and services. It is submitted that though there have been amendments made to the Act relating to online gaming, including online money gaming, the said amendments specifically adverting to aspects of deposits are matters which would operate prospectively, that is after 1/10/2023, and cannot be extended retrospectively for the assessment year 18-19 in the case of the petitioner. In the light of so and so, Your Lordship.
Yes. In light of the contentions raised and noticed in the order of 16/7/2024, there would be an interim order of stay of
A, Your Lordship.
Annexure A. Respondents are at liberty to seek for modification of the interim order upon completion of instructions and filing of statement of objections. Yes.
9. 39, Ravi Raghav.
Please.
Yes.
This is a challenge to a notice proposing to demand refunds which have been sanctioned to me on account of exports made by me. The order sanctioning refund, my lords, under 89(4) have not been appealed by the department. They have not been challenged. They have attained finality. Thereafter, my lords, the department has issued this notice contending that I am eligible for refund under Rule 89(4)(b) of the CGST rules and not 89(4) which I had initially claimed and which has sanctioned to me by the proper officer. Nowhere, my lords, there is a dispute that I am not eligible for refund on merit because the refund is on account of exports made by me without payment of tax. Two types of exports I can make, my lords. One is on payment of IGST, where I get the refund of the IGST paid. The second type, my lords, I can export under letter of undertaking without payment of IGST, where I am eligible for refund of the unutilized credit available with me. Since I import goods under advance authorization, I did not go into the first option of paying IGST because there is a restriction of claiming the refund under 96. That provision, that issue, in fact, is pending before the various, like including this court. So I opted for export without payment of tax under the letter of undertaking. I applied for refund of the unutilized credit available with me in my books under Rule 89(4) of the CGST rules. Rule provide for refund of unutilized credit. There is a formula prescribed. In terms of the formula, I applied for refund. Refunds were sanctioned to me by the proper officer. After, my lords, the refunds have been sanctioned after 4 years, my lords, the present notice has been issued to me contending that I should have ideally claimed refund under Rule 89(4)(b) of the CGST rules, which is applicable to me because I have imported goods under advance authorization, and for such assessees, there is a separate provision under 89(4)(b). Therefore, I should have gone by that provision. I challenge, my lords, the audit objection, the letters, etc., saying there is no restriction in me claiming refund under 89(4). There is an option available to the assessee. I have claimed under 89(4), which has been sanctioned to me also. I had also alternatively submitted. In any case, if my refund under 89(4)(b) is more than what is already sanctioned to me, therefore stop with the recovery proceedings. Despite that, my lords, the present notice has been issued proposing to recover the refunds which have already been sanctioned to me by speaking orders of the proper officer, and all those orders have attained finality. The orders of, my lords, of 2019 to 23, the time limit for filing appeal is also gone. For example, my lords may kindly come to page 12 of my petition.
Yes.
This table, my lords, at page 12 is the details of the refunds sanctioned by speaking orders. It starts from order dated 15th of July 19. My lords have it in serial number 1.
Yes.
It goes on, my lords, till the period March 23, where the last order was passed on 20th of July 23. And all these are appealable orders. Department has an option to file appeal against these orders. According to us, till date, no appeal has been filed. The time limit for filing appeal before the first appellate authority is also gone, including the condonable period also is elapsed. Now, my lords, by this present show cause notice, they propose to recover the refund which has been sanctioned to me.
Yes.
That's page number 59. 59 minutes. The statement made by the petitioner 4.17. 4.17. As may I read minutes. I'm being asked as you are aware that Rule 89(4) was amended with a notification number 54/18 Central Tax dated 9/10/18, and sub-rule 4B of Rule 89 was inserted with effect from 9/10/2018. I am showing you the set rules. Why have you not followed the same? why you have chosen to ignore the amendments and continue to file the refund claim under Rule 18 and 4, despite the fact that you are specifically required to file refund claim under Rule 18 and 4B, as you have now revealed that you have been taking the benefits of notification referred to in the said sub-rule 18 and 4B. The deponent stated that I wish to state that we had no clarity over the said notification. That is why we filed the refund under Rule 18 and 4.
Because my lord, 18 and 4B.
Now, it's a factual error which they have committed. And now they want to claim the benefit of their own. The funds which has been.
No, but he's entitled for refund either under 89.4 or 89.4B.
May I request?
Either way. It's only recovery we will.
What I request, man, there is no, it's only show cause notice which has been issued.
No, sir, we'll only say.
And kindly see the last, this thing, my lords, he was supposed to come before the authority and make submissions. Kindly see the page numbers 871. Okay. Page number 77. 77, paragraph 13. 13. And lords, may I read? They are further directed to submit their written explanation within 30 days from the receipt of this show cause notice. They should also specify mention as to whether they wish to be heard in person or through their representative before the case is adjudicated. If no cause is shown against the action proposed within the stipulated time, or if they fail to appear before the adjudicating authority when the case is posted for hearing, the matter shall be decided.
Correct, but the contention is once refund is made and that has not been challenged. Now you cannot seek for recovery without those refund orders being set aside if they date back from 2000.
There are possibilities. His claim is 89.4. Our department has said that 89.4B.
No, but that has not been challenged by you. Now you seek to recall it by virtue of the present proceeding. So let us see.
There is no.
Sir, we have challenged the provision of 89.4B to be read on because there is no procedure prescribed as to how the refund under 89.4B is to be claimed. That is also under challenge in this petition.
Lordship, may I request?
And this has been considered.
Indulgence. Kindly have to next week, madam. Two things which I would like to clarify in that is, with regard to challenge to the rule itself, we will file similar objections, so that is concerned. As for this factual aspect of granting the refund and now proposed the show cause notice and referring to two sections of itself, I will take instruction and make submissions. Next week, any date may.
Refund orders on record. Refund orders on record. My lords may kindly see page 111.
Let him complete his instructions,
My lord, till such
but
time,
no recovery.
no precipitative action till such time.
My lords, what has been said according to me, it's only notice, show cause notice. Nowhere it is.
No, correct, but if we were to submit to jurisdiction, then
They'll adjudicate their one.
point of jurisdiction will go. Let us see. You take your stand in writing. Subject to further consideration in light of the contentions raised, respondents not to take any precipitative action consequent to the notice to show cause.
Annexure A.
Counsel
Date.
at Annexure A. Learned counsel for the petitioner contends that the orders of refund not having been challenged and having attained finality are sought to be reopened through the present proceedings through show cause notice at Annexure A. Matter requires consideration. Idin melagi. Yes.
Oblige. Great.
40, Pradeep.
That in this case, 148 AD order has been passed ex parte.
Just 1 minute. Income tax.
Sushal will appear. Sushal will.
Learned counsel Sushal is directed to accept notice for the respondents. Shall we have it next week?
Yes, beloved, they have directed me to file the return under 148. Here in this case, the 148B notice, lordship, is issued less than 7 days. And D order has been passed within 1 day ex parte. And the assessee is a 74-year-old person. First time.
What is the date of notice?
Date of notice 29/3/24. which is on a Good Friday. Compliance on 6th, which is a Saturday, which gave 5 clear working days, 5 days clear
Copy of notice at
at page 30, my lord.
page 30.
30. Annexure A. And this was also sent by mail, which mail had gone to assessee's daughter.
No, this notice is dated 29/3.
29/3, which is a Good Friday. Compliance, my lord, is on 6/4, which is a Saturday. And 30th and 31st is a Saturday and Sunday, giving 5 working days. So this court has held, my lord, that unless 7 days notice is given, the proceeding under notice under B is invalid.
We are saying 7 days clear.
Clear notice is not there.
The Act says 7 days.
My lord,
Admittedly, we've given 7
kindly
days.
refer to
Those
WP.
cases in 148 AB notice itself, we had given less than 7 days. Those matters are being quashed. This is the clear case where we've given 7 days.
There's also a decision in 450 ITR 143, where the non-working days must be excluded in calculation of 7 days. That I will just give the decision, my lord.
Engineer. Paragraph.
My lord, in Giridhar Gopal Dalmia,
Yes.
4 and 5.
para 4 and 5, which I have extracted in para 12 of the petition.
Para 4.
Yes. Therefore, the statute gives discretion to the AO to fix the notice period, and such time limit has to be fixed, bearing in mind the principles of natural justice, that the assessee should be afforded reasonable and adequate opportunity. The show cause notice issued under section 148A(B) of the Act was received online by the assessee on 17th March 22. The impugned order has been passed on 29th March 22. And according to the AO, the assessee has not produced any document to substantiate his claim. To be noted that 17th March 22 was declared as a state holiday on account of Holi festival, and 18th March 22 was also declared as a holiday, 19th and 20th March being Saturday and Sunday. Next working day is 21st March. Therefore, the period of notice issued to the assessee cannot be stated to be affording a reasonable and adequate opportunity to the appellant assessee.
Let us see. The order, next order is passed on the next day.
Very next day, on 8th.
I'll take notice, it's next week.
This consideration of interim prayer is kept open. Relist the matter on
Next Tuesday.
Tuesday.
Till then, ABC may be stayed, Lordship. BC.
No, but now what are they doing now?
No, Lordship, they are asking me to file the return under 148, even that there is no escapement of income. On merits, my lord, it's like this. In 2008, I agreed to sell some land and entered into an agreement.
Lordships may
Received the consideration.
Lordships may kindly consider to stay further proceedings subsequent to 148. Your Lordships may kindly have it next Tuesday itself. Because once 148 notice is issued, within 30 days there.
July 29th, the 30
They have
days.
to file returns. Your Lordships may kindly consider to stay further proceedings
Yes.
subsequent to 148.
B and C.
In light of the contention raised, including that clear notice of 7 days was not afforded, and the order under 148A(D) was passed on the very next day of the date fixed for reply under the notice at Annexure A. The proceedings pursuant to
148 notice.
148 notice are stayed.
Next year, B and C.
B and C are what? What is B and C?
B order and C is 148 notice.
No, now we have stayed further proceedings. Let us.
Yes, yes, that will be sufficient. Much obliged.
Sushal may be directed to notice.
Yes,
So your
let
lordships
also
may kindly
Sushal.
fix the date next Tuesday, my lords, we can,
Yeah.
I'll get instruction.
Date good. Vishal is directed to accept notice for the respondent.
41.
Much obliged.
Please, please. My lords, I am a goods transport agency
Yes.
who is providing services to various registered SSCs. In terms of the provision of section 9(3), my lords, and notification 13 of 2017, the recipients are required to pay tax under reverse charge mechanism in respect of whatever services they obtain from a GTA. I raised invoices on all my recipients saying this is the total cost of my supply. Tax is required to be paid under reverse charge mechanism. I have clearly indicated on the invoices. Therefore, the liability is on the recipient in terms of law itself. Though I have an option to pay under forward charge, but in this case, clearly I have indicated it is to be paid under reverse charge mechanism. Audit was conducted. Audit objections were raised. Audit report was issued, in response to which each of the time I had responded to them. And the objections always was, my lords, we have not given proof that the recipient has discharged tax. The audit objections clearly laid down that the audit ADT2, that is the audit report, also clearly indicated that we have not given proof that the recipient has paid tax. My lords may please come to page 76 directly, my lords. It's the first audit objection. 76.
Yes.
92 straight away, my lords, 92. It starts at 91. So this is one of the objections which continue by the impugned order. It starts at 91, observation 3. My lords have it?
Yes.
In that, my lords may please come to page 92 top. For observation 3, the reply filed by the DAR is verified, and in the absence of proper documents to prove the service recipient discharged the RCM tax, the exemption claimed by the taxpayer is disallowed and tax interest liabilities worked in the observation is confirmed. So this is what, my lords, the audit objection said. Show cause was issued pursuant to this audit objection on similar lines at page 105, my lords. (105) top, my lords. This is the show cause notice.
Yes.
For the observation 3, reply for the DRA is verified in the absence of proper documents to prove the service recipient discharged the RCM tax, the exemption claimed by the taxpayer is disallowed and tax interest liability is confirmed. This one is the show cause notice. I responded to this saying clearly, the liability is on the recipient under reverse charge mechanism. I have raised invoices clearly indicating tax to be paid under reverse charge. Therefore, drop the proceedings. You cannot force me to give information of the recipients having been paid tax because law doesn't contemplate such a requirement.
Where is that entry reverse charge mechanism?
My lords may please come to my tax invoice at page 60, my lords.
No, which is the entry?
My lords, I'll just give a compilation. The notification, my lord, the provisions of section 9 is at page 293, my lords.
Yes.
The government may, my lords, have 93 in the middle of the page. On the recommendations of the council, by notification, specify categories of supply of goods or services or both. The tax on which shall be paid on reverse charge basis by the recipient of such goods or services or both, and all provisions of this act shall apply to such recipient as if he is the person liable for paying tax in relation to the supply of goods or services or both. In terms of 9(3), my lords, notification was issued, which, my lords, is at page 5, serial number 1.
Yes.
Category of supply of service, my lords, have in column 2. Supply of services by a goods transport agency GTA in respect of transportation of goods by road. D, my lords, D.
to any person registered under the CGST Act or the Integrated Goods and Services Act or the State Goods and so and so. Supplier of services is the GTA. The recipient of service person liable is D, my lords. Any person registered under the CGST Act, IGST, is the person liable to pay tax. I therefore reply to the notices contending the recipient is liable to pay tax. Law doesn't mandate me to give the details. In fact, my lords, what has happened in the order? Sorry.
If you irritate him too much, then he'll.
I'm sorry.
In light of the contention that insofar as the supply of services by a good transport agency, the obligation to bear the tax liabilities on the recipient of service under the reverse charge mechanism in terms of
Notification, page 6, my lords, bottom, 13 of 17, page 6, bottom. My lords.
in terms of the notification 13/2017 dash central tax within bracket rate, comma, dated 28/6/2017. There will be a stay of
Annexure A, my lords.
Annexure A. And Council Shamat Naik accepts notice for the respondents. Respondents are at liberty to seek for modification of the interim order upon completion of instructions and filing statement of objections. Yes.
Obliged, grateful.
42.
It's reassessment proceedings on a non-existent entity.
Yes.
It's a covered matter. Lordships have already passed in Nassi's own case.
Done, no? Over. Squarely covered, my lord, by earlier order of your lordships.
What are the facts?
This is the assessment year 2018-19.
Now which is the entity as against which they issued notices?
Same. Identical. 70, this is 17-18. What your lordships have already passed an order. This assessment year is 18-9.
When you say same, you must say which annexure changed. Otherwise.
Annexures, my lord, I'll just point.
Identical order can be passed. So you make pencil markings of the annexures.
I'll do that.
Otherwise identical.
Identical.
No change.
No change.
Then make pencil markings.
Yes.
Disposed same or pencil marking marker. A bit marking.
Only annexures.
When we say identical, it must be identical.
Yes, yes. Facts are identical.
No, I'm
There's
saying-
the assessment year difference.
Correct.
Annexures will change. I'll.
Yes, except that contents of the order are same.
Same.
Make the pencil corrections and
Yes.
give.
Yes.
Disposed. 43.
Matter had come last week, my lord. Order of adjudication, my lord, is under challenge. But petitioner, my lord, is a real estate company.
Yes.
Had undertaken development of a project. But the project, my lord, was conceived in the year 2013. But there was delay, my lord, in the project. However, my lord, there was introduction of RERA authorities. But where we are supposed to, my lord, obtain a certificate of registration. My lord, if the project comes within the purview of the act, but if more than 8 apartments need to be built, my lord, they'll have to, my lord, register under RERA Act. But the project where is, my lord, this is comprises of about 118 apartments. My lord, under those circumstances, my lord, we intended to register under RERA authority. But submitted all the documents, my lord, obtained, my lord, a certificate of registration. The act came into force 2016-17, my lord, we were given, my lord, the permission. At the time of, my lord, obtaining permission from the RERA authority, my lord, until the year 2017, because, my lord, they specify, my lord, a certain period, my lord, from the date of application to, my lord, within which period the project will have to, my lord, get completed. So 31/7/2019. After the act came into force, my lord, all my lord, the developers were given that, my lord, that as the subsisting period for the certificate of registration. Under those circumstances, one of the requirement is we'll have to, my lord, furnish, my lord, the cost of the project, and also, my lord, as of that day, whatever, my lord, is the amount that we have received, my lord, and out of the project and the expenses incurred and so on and so forth. So at that point of time, Lord, until the year 2019, Lord, we had submitted, my lord, by the amount of, my lord, 53 crores. Whereas total cost of the project was 108 to 10 crores, my lord, what was, my lord, declared. My lord, the authorities source the material from RERA. And, my lord, say that, my lord, until the year 2019, we had, my lord, spent all the, my lord, we had a turnover of about 110 crores, which is the cost of the project. That is not, my lord, factually correct, because as on 2019, project itself, my lord, was not complete. 2022, my lord, we have completed, my lord, and my lord, we have applied for OC, my lord, which I have placed before the court, as well as, my lord, before the authority. But please take, my lord, the order of adjudication that is there. Then page 26.
Yes.
Out of the project cost of 104 crores, so the company has declared only a turnover of rupees 51 crores 74 lakhs 42,327 from September 2013 to November 2019, and remaining turnover of rupees 50 crores 38 lakhs 57 lakhs has not been declared, resulted in less payment of CGST and SGST. This is factually incorrect, because as on 2019, the project was not complete. They take into account, my lord, the cost of the project being 104 crores. They assume that, my lord, other 52 crores, my lord, is the profit which will, my lord, is the turnover amount. Thereafter, my lord, a reply, my lord, detailed reply was.
Let me seek
Please, I'm
instructions.
sorry.
my lord. Let me seek instructions, my lord, on this.
But in fact,
I have
last
it next
occasion it
Tuesday.
was listed. What has happened is fine levy warrants are issued, my lord, criminal prosecution we are facing. But in fact, last occasion also, my lord, they took, my lord, time to seek instructions. My lord, the detailed objections were filed, my lord, they do not hear us. After the orders are passed, my lord, we also, my lord, submit further documents and seek, my lord, personal hearing. In spite of it, my lord, the endorsement is issued, no such, my lord, hearing could be afforded.
Page 25, my lord. Below that box, show cause notice duly served on, my lord, duly served as per section 169 1C and 1D of the GST Act 2017. But the company has neither filed a reply in GST portal nor the office government.
No receipt of, my
mail on
lord,
the-
show
on
cause
the-
notice
on
is
the-
not in dispute. We
The
don't
company has also failed to produce books of accounts, hence issued reminder on 4/8/2023, 14/8/2023. After issue of second reminder, chartered accountant appears before the office on 17/8/2023 and filed a letter dated 14/8/2023 along with so-and-so documents. So all these documents are now placed. Based on that, we've passed our order. Now, my lord, now there only, my lord, 73 order has been passed. You can file an appeal, my lord, under 107 also. Don't see why they.
Yet another ground.
Everything has
my
been
lord, is
considered.
The hearing ought to have been afforded, my lord. In fact, my lord, this covered.
Personal hearing he has come before the authority. That itself is personal hearing.
Let him complete his instruction. We'll have it next week.
My lord, the squarely covered by your lordship's judgment in Bangalore Power Club. Where, my lord, your lordships have observed, my lord, opportunities to go. But your lordships have not considered.
Let him complete his instruction.
I understand, my lord.
We'll
But
have it
what has
next week.
happened is, not fine levy warrant is, let them not precipitate the matter, my lord. My lord, I'm happy. Last, my lord, almost 8 days back, my lord, the matter came up, my lord, that they similar.
This is an order of 23.
No, I understand, my lord. We were not served with him, my lord, any
Let us
notice.
Wait for a week. Let him complete. Let us see what stand they take and we'll see.
Grateful.
Consideration of
All that, my lord, I am urging is, I was not heard, my lord, beyond that, my lord.
let us see. They may
If, my lord,
consider.
the order does not show that, my lord, I was at any point of time heard, my lord, before, my lord, levying the tax.
He may concede. He wants to complete his instruction. He may concede. on the next date, let us. At request of learned counsel for the state, relist the matter on
Any date.
Between Friday, my lord, Friday.
sixth.
Matter is there today before the magistrate. We have said that, my lord, the writ petition is before this honorable court
Let
today.
us see, let us.
My lord, that would be too long a date, my lord. But what, my lord, if they, my lord, proceed further, my lord, we would be, my lord, arrested, my lord. Please look at, my lord, the
We can't-
situation we are placed.
So please look at the date of the order.
No, my lord, I understand, my lord.
So
we-
they just
we were-
wait till the next date.
In fact, my lord, after the order was passed, my lord, we also, my lord, wrote to them, my lord, please look at, my lord, the
Let us see,
annexure.
let us. Yes, next.
At least an earlier date, my lord.
He has to complete. If he completes, I'll give.
10 days back, my lord, I was before the court, my lord. They took time, my lord, on the same, my lord, grounds, my lord, to
You have
seek
to wait.
instructions.
You have come late, you have to wait. Let us. Next.
44.
44, my lord, is a royalty matter.
Yes.
Page 64.
I think some judgment is due to come.
Yes, my lord.
Today or tomorrow. That's why they're hurrying up.
Page 64. I'll take notice, my lord, for 1 and 3.
In light of the similar questions being matter of consideration in other matters. And also in light of the interim order granted, Aditya understand.
Page 61.
Aditya same order.
Stay of annexure A and B, my lords. All further proceedings.
Any or a stay of annexure A and B.
Further proceed, all further
Proceedings
proceedings.
pursuant thereto. Yes. And Council Shaman Naik accepts notice for the respondent.
Madan Pillai, my lord, for 2. Madan Pillai for 2. Mr. Madan Pillai for 2, my lord.
Then
Union.
Council Madan Pillai is directed to accept notice for the
Second respondent.
second respondent.
45.
Yes,
Week's time to comply with the office objections, your lordship.
a week's time granted for necessary compliance.
46.
Here for the petitioner company, my lord, they manufacture certain ready-to-eat products which are called as namkeen in the market. Now, on this, according to the government of India notification, they are chargeable to 12% rate of duty, my lord, which we have been doing it from more than 10 to 15 years. Now, in the GST meeting, they say, no, instead of 12%, it should come under another entry, which is chargeable to 18%, which deals with pastries and other bakery products. And on that ground, my lord, on the GST meeting, a tax research unit issues a circular saying that 18% unit should be, 18% rate of tax should be charged. On that basis, my lord, the show cause notice has been issued. When we, my lord, seek for clarification in the show cause notice, they say the issue stands settled by the TRU circular itself, my lord. That your lordship get it in the show cause notice at page 65, my lord, is the show cause notice. Relevant page at 112.
Yes, Jeevan, you appear.
Yes. Respondent.
It has to be served.
Courts have taken the view, this tax research unit, my lord, has no legs to stand on. Even assuming, my lord, if there is any classification issue, it will have to be settled in an adjudication procedure, not the Government of India sitting in the office, my lord, cannot issue that circular. Matter is covered by judgment of the Supreme Court as well as by the Delhi High Court. Delhi High Court has taken the view this tax research unit cannot do it. Even the board itself cannot do it, my lord, under section 168.
But let him have a look at it.
Lord, what they are doing is, kindly see, my lord, the show cause notice. The show cause notice pertains to the products which are being manufactured and supplied, marketed throughout the country. Now, after issuing show cause notice, they are going on detaining our products itself at different places. Now, we are paying 12% rate of tax from past 15 years. Kindly see the notice, my lord, which is issued now at page 66. It pertains to different places in the country. Because of this notice, they are straight away detaining our vehicles at different places. And this show cause notice itself, my lord, is based on the circular. Now, if the Supreme Court has taken the view, once such circulars are held, it is binding on the quasi-judicial authority and that can't be issued at all. In fact, my lord, I can demonstrate from the reading of the classification itself. If your lordship look at the notification at page 188.
We'll have it next week, let him complete his instruction.
Okay.
Let him complete, he wants it in.
Days before your not similar. She was this. 2 minutes, I will say. Only 2 minutes. Whether the product should be classified in chapter 21 or chapter 19. The Supreme Court has settled this classification by lords. The series of judgment of the countries.
It is there. We have made a compelling.
The namkeens has to be classified only under chapter 21. Now, contrary to that decision, my lords, GST Council and a circular is issued now saying that these products cannot fall under chapter 19. The only reason being that they want to collect 6% extra tax. It's the only reason.
So let us see, but let him take some preliminary instructions.
Lord, what they have done is, what
Being contrary. My lords, and past a similar matter was considered by my lords between 21 and 8. Lordships would see here.
We'll have it on Friday, have a look at it. Some preliminary instructions insofar as the interim prayer. Friday.
they have given the time of till 30th, my lord, to file our objections. And they are taking precipitative coercive measures outside of the state also.
Friday.
What is on 29th? Monday.
And just 2 minutes, I will show you a lot of the
No,
decision.
no, let us see. Normally, you know the procedure I follow. I give them one.
Acutely.
Friday probably, my lord, last.
Let us see.
There will be more pressure.
He lists the matter on 29th. Consideration of interim prayer is kept
Monday.
open. He wants it on 29th. Let us. Yes.
No, because 38th is the last day, my lord, within which we have to file. They have already fixed it for personal hearing.
And they're detaining the lorries also, 129.
If they are, let them not take coercive steps, my lord.
Kindly gives us 2 minutes, my lord, and demonstrate your lordship how this order will be applicable. The same order.
So let him have a look at it. When do you want, Jivan?
Monday, my lord, 29th.
29th.
Tomorrow, Friday, let them have it.
Let us see.
Monday, last date for filing objection itself is 30th.
Yes.
But on Tuesday.
Friday.
Tuesday, ಒಂದಿದ್ದಲ್ಲಿ ನಾವು ಮಾಡಿ ಹಾಕ್ಬೇಕಲ್ಲ.
My lord, to keep it kindly on Friday, it will help.
My lord, I have to get instruction, I have to give copies to them, my lord.
Monday. Yes, Monday. Yes.
47.
That time, let them not take any proceedings.
I will not take any questions. I will not take.
Your officers, that's what I'm trying. They will not let us see also. Forty-seven?
Yes.
This 47, your lordship, can connected, your lordship, to the matter at 76, your lordship. Lords will recall this matter. I had given a chart, your lordship, in 76 last time, your lordship. I'll just take 2 minutes to explain from the chart, your lordship.
Yes.
The date. Lords will see. Lords will recall this chart which I had given your lordship in the matter. A series of about 6-7 writ petitions were filed on the same issue. On the ground, your lordship, that I am an intermediary. It is our case, your lordship, that we are not an intermediary. It amounts to export of services, and we are covered by a circular. And in spite of that, your lordship, multiple proceedings are being initiated, notices are being issued, orders are getting passed, and we are filing writ petitions, your lordship, religiously, and my lords are giving us protection in terms of stay orders. Now, once this batch came, your lordship, I had pointed out to my lords that this is increasing the proceedings before my lords, especially when a circular issued by them covers me. Then my lords heard me on 3rd of July, 26th June. 26th June, your lordship, my lord said, in fact, the first writ petition, your lordship, was somewhere in March 2023, your lordship, when notice was taken. And from March 2023 till now, that is July 2024, counter has not been filed. So on one hand, your lordship, counter doesn't get filed here, matter gets adjourned. My lords admit these writ petitions and then the stay orders are passed. On the ground, they keep passing orders against us, your lordship. So we tell them that the matters are pending before the High Court, stay is granted. They don't listen to us, they proceed to file to adjudicate the matter.
The case
Now
of
on, yes, just 1 minute only.
in the case of the same SSC.
Same SSC. Same SSC, different periods. My lords will see the periods. October 2017 to September 2020, your lordship. Series of proceedings, different refund claims. So on 26th June, your lordship, my lords had permitted us to argue. We had argued extensively. About 60-70% of the arguments were over. Then, your lordship, it was supposed to continue on 3rd of July. And on 3rd of July, your lordship, we were told that the matters have been reallotted to various people, and therefore few people will come on record. Counter was supposed to be given. And my lord said that we'll have it on 23rd, which is yesterday. They wanted time till today, 24th. Till now, your lordship, we don't have the counter.
Who appears?
I appear on not two or three matters, my lord. I think Arvind Chavan appears in other matters.
In fact, today, your lordship, my lords had indicated that my lords will indicate at 2:30 today. The last daily order, your lordship, my lords had indicated that, but that's fine, your lordship. Now, before, that is one position, your lordship. Now, if my lords could see this chart, we have mentioned 2 writ petitions which we have now filed afresh. 19535, my lords have it, your lordship. 19535 of 2024, that is highlighted, your lordship.
Yes.
The my lords will see the ordered and original, your lordship, was in our favor, and on the top, your lordship, April 2020 to September 2020. The order, your lordship, was in our favor based on the circular. Circular, your lordship, was in September 2021. This order, your lordship, is passed in May 2022, giving us the benefit. That, your lordship, is they challenge that order in original. They file an appeal to the Commissioner Appeals. beyond the limitation period, Commissioner of Appeals dismisses it on limitation. Therefore, that order becomes final as far as the issue of intermediary is concerned. Simultaneously, Your Lordship, they issue a show cause notice. My Lords will see. Show cause notice dated 12/12/2022. Same column, Your Lordship. We tell them that the matter is pending, and when I came on the order in appeal, my Lords granted us a stay. No further proceedings to be taken. In spite of it, Your Lordship, they are going ahead with the adjudication of the show cause notice. So we had to file this writ petition. The third PH also has been issued, Your Lordship. That's one. My Lords will see for the earlier two periods, the lead matter 13/007 of 2024. Also, Your Lordship, there was a show cause notice that was issued. We came on an appeal against the order in appeal. My Lords granted us a stay, saying that no further proceedings to be taken. They had issued a show cause notice. Now they propose to adjudicate that show cause notice also. Therefore, an IA, Your Lordship, has been filed seeking protection, Your Lordship, against the adjudication of that show cause notice. So all matters stays are in our favor. And two matters, Your Lordship, 19535, Your Lordship, the stay has to be extended to the show cause notice. And in 13007, there also, Your Lordship, the stay has to be extended to the show cause notice. That's what prayer, Your Lordship. Second, this matter, Your Lordship, has been argued by me in quite some time before my Lords. Now they have to respond. Neither the counter is filed, nor arguments are advanced. Number of writ petitions are getting increased. So our request, Your Lordship, my Lords will post it on any day at 2:30. They want to file the counter, let them file, Your Lordship. Otherwise, my Lords will hear me on the matter.
Getting ready. Day or two, my lord, I'll file. This week.
When?
Well,
When?
some of the matters are posted on sixth, my lord, I think. in
No,
morning
no
the-
matter is posted on 6th, Your Lordship.
Columbia and Waters, they are posted on sixth, where intermediary and export, my lord, that, my lord, but that is the previous regime, service tax regime, morning, my lord, submission. Can be posted, my lord, any date convenient to him, make posted.
They have to
Where
file a
we are-
counter, Your Lordship. Let them file the counter. My Lords will have it on 8th, Your Lordship.
Release the matter at 2:30 on 8th.
Yes.
The respondents to complete instructions by such date.
And stay to be extended in these two matters, Your Lordship.
Interim order earlier granted.
That
In-
earlier stay order, Your Lordship, is at
In WP, in the.
in WP 19535, Your Lordship, we need a stay. And
Now this, we will link it along with 76.
yes,
WP 19535 up to 24 to be called along with seal number 76 and connected matters. Where is the interim order passed in other matters?
page 136, Your Lordship, in writ petition 19535. Page 136.
And senior counsel.
At page 144.
For the petitioner submits that in the case of the SSC itself, where an identical issue has been raised, interim order was passed in WP
007 of 2024. Your Lordship.
2024 on 12.
This, Your Lordship, was passed.
2024.
Yes.
On 12/6/2024. Same, huh?
And in the other
The
matter, Your
interim
Lordship,
order passed reads as follows. Next, in light of the same, there would be an interim order of stay of
Annexure A, Your Lordship.
Annexure A. And senior counsel appearing for the petitioners. ಆಮೇಲೆ ಇದು 76 ಅಲ್ಲಿ ಬರೀರಿ ಇದಿಷ್ಟು ಸ್ಟೇ ಆಯ್ತಾ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಆರ್ಡರ್ ಇನ್ 76 and senior counsel appearing for the petitioners has filed a chart with details of writ petitions filed by the petitioner and submits that all orders in original were passed in favor of the petitioner and subsequently reversed in appeal.
Reversed in appeal.
It's further submitted that unless the matter is resolved at the earliest, there would be multiplicity of litigations. Taking note of the details of the litigation, as is evidenced by the chart produced, respondents to complete their instructions in all the matters by the next date. Please notice that many of the petitions relate to the year 2023. Relist the matter at 2:30 on 8th.
In 13007, Your Lordship, we had filed an IA along with the show cause notice and for amendment of the prior, Your Lordship. That IA needs to be allowed. Stay needs to be allowed. And stay granted on the show cause.
In WPA
13007
of 2024.
Yes.
That is serial number 76. Put it. IA 2 of 24 has been filed.
2 and 3, yeah.
Seeking for modification of the main and interim prayer. Taking note of the affidavit filed in support of the said application. Application is allowed. Amended petition to be filed.
Stay of show cause.
IA 1 and 2 of 2024 have been filed.
Where's the show cause?
IA
1 and 2 here. 2 and 3 here.
IA 2 and 3.
11 ಇದು IA for amendment is 2. ಆಯ್ತಾ? IA 3 of 24 is filed for production of additional documents. ಆಮೇಲೆ ಇನ್ನೊಂದು ಇರ್ಬೇಕು. ಸ್ಟೇ ಅದೇನು ಇದು amendment.
Annexure M has to be stayed.
The application for modification. Application for production, 3 of 24 for production of documents is filed. The senior counsel appearing for the petitioner submits that in light of the subsequent order at annexure.
The show cause, Your Lordship, but annexure M.
In light of the subsequent show cause notice passed during the pendency of the petition at annexure
M, Your Lordship.
At annexure M. It requires to be passed an interim order of stay of
annexure M. Well, we had filed the show cause.
S, I think S.
Yes, sir.
No, just one minute. Sure, sir. Just check.
On 8th, Your Lordship, at 2:30.
Just a minute. There's some confusion on the, which is the annexure.
M.
Annexure M. Annexure M.
Main petition ಅಲ್ಲಿ ಆಗ್ಲೇ ಆಗುತ್ತೆ. Already ಬಂದಿದೆ.
There has to be stay of annexure M. Also, in light of the earlier interim order passed. Earlier interim. There will be stay of annexure M as well. Release the matter 2:30 on 8th.
8th.
Yeah, in 19535, Grant Council,
19535.
who is going to accept notice?
Jeevan.
Jeevan, you accept who?
Please. Central tax.
No, Central
Tax.
Grant Council, Jeevan accepts notice for the respondent. Yes.
Petitioner is a student, my lord, in the third respondent college, law college.
But before my learned friend begins, similar matters were heard by the Honorable Court and reserved.
Shortage of attendance.
Shortage of my lord's attendance, they did not appear, my lords, in the previous semester, and they want to attend the classes for the subsequent semesters.
Just 1 minute.
Please.
I'm pronouncing that tomorrow at 2:30.
Please, my lord,
So we'll have this tomorrow.
please, my lord. The only difficulty in this, my lord, is the student has already paid the entire fees for classes and for hostel. Now he's he's from Tamil Nadu, my lord, not from a very good circumstances. They are now being told that you please vacate the hostel as well. At least, my lord, let them not disturb the boy, my lord, from staying there, because he has no other option in Bangalore, my lord. This is not his hometown.
You're correct. Now, let's assume the worst case scenario that he may have to take it up once again.
Please, my lord.
Hostel fees you will pay, you want to stay there till the next.
At least till the decision is taken by this honorable court, my lord. In the event, my lord, I don't succeed and I have to restart this semester, the first year. Of course, my lord, they will.
No, which semester you are in now?
First semester is done, my lord. Second semester, I have not been allowed to attend second semester at all.
First semester, he did not write because of shortage at.
Para 11 may please be seen, my lord, of my writ petition. Para 11, I'll just take 2 minutes of.
No, just tell me you are now in which semester?
I'm nowhere, my lord.
No, correct.
First semester exams I wasn't permitted to write. I'm not permitted to attend second semester classes. So I made representations.
No,
I'm good.
I have one question. Suppose you had to restart.
Please, my lord.
Then you'll have to restart the first semester.
No, my lord. I would be permitted if I'm permitted to attend classes now.
No, correct.
I can attend second semester and I can write the supplementary for the first semester.
No, correct. There's an issue. Let's look at it as the worst case scenario.
Please.
Now let's assume that you are not permitted for the second semester or write the first semester exam. Then you'll have to restart from the first semester.
Please, my lord.
Now, when is the first semester of the next year going to start?
September, my lord.
September of.
Please, my lord.
September, my lord. August 18th is the even semester examination that is going to be conducted, my lord. 1 month it might happen, my lord. So from September,
he has to restart.
The academic year starts, the odd semester starts.
In fact, classes for this semester started from May 8th, my lords. We are already in July.
Okay, but at least he must be permitted to stay in the hostel.
Lords, till my lords, this court takes a decision. My lord. Anyway, lordships are having the matter tomorrow. My lords.
That is
In
the
the
thing. I'm saying irrespective of that.
Please.
If he's from outside, you can't drive him back there and say, I'll come back and.
According to my lords,
Now
contention.
we are already in August.
Please.
Isn't it?
Please.
We are in August. There is only 1 month now.
Please,
my lords. Anyway,
Just
lords.
saying, worst scenario.
I understand.
So in worst scenario, you can't ask him to go out of the hostel.
Anyway,
But
my
under
lords, your
circumstances,
lordships are
my
having
lord.
this matter tomorrow, my lords. I'll take instructions and my lords, I'll make submissions on that.
No, you can't drive him out even.
I understand, my lords. I'll convey that to my lords, the institution.
My lord, even if there's no order to that effect, if my learned friend at least instructs his clients, my lord, tomorrow, my lord can consider whatever interim prayer I'm seeking. But my lord, our fear is the reason we also moved the matter, my lord, with urgency was that he's being told you leave now immediately.
No, no, that cannot be done. We will pass that order. And I know what orders I am passing tomorrow. Or we'll pass it tomorrow.
Tomorrow, my
Please,
lord.
please.
Only tomorrow, so which is why, my lord, my friend's words I can always trust, my lord. That's been my experience till now.
Then, now you have served, isn't it?
Please, my lord, both have been, sir.
Then Council Shri Girish accepts notice for respondents.
Two, my lord.
Two.
One is the state, my lord.
AG accepts notice for the first respondent. Then Council MP Srikanth for the third respondent. All your prayers for tomorrow.
Please.
Please.
Matter will be listed tomorrow, my lord.
Yes, yes, release tomorrow at 2:30.
Please.
Grateful, my lord.
Much obliged.
ತಗೊಂಡ್ಬಿಟ್ಟ ಯಾವುದು ಅಜ್ಜನ್ ಆಗಿರೋದು ಎಷ್ಟಿದೆ ಹೌದಾ We'll take it up next week. Next week.
Otherwise a covered matter, I'll leave it to your lordships. It's a fully covered matter.
Next week, yes.
50,
Would your lordships fix a date next week? I understand there may be.
Sixth, yes, next.
50, Srihari.
Next
Appearing
week.
for the petitioner, my lords. Very
Next
short
week.
matter.
No, next week. I have to wind up. I have one part heard which I have to complete.
Progress.
51 to 53.
My lord, very late.
Pleadings are still not completed, my lords. I am yet to receive the petition, my lords.
List after 2 weeks. Yes, next.
Date 51 to 53 urgent. 54. Till number 54. Balram Rao.
Next week.
Lord, that 49/6, I have some interviews. Can it be on 8? 8.
Yes, 54, next week.
A date may be.
Date.
6th August.
6th August.
55. Manoj SN.
My lord, I appear for respondent. My lord, in this matter, the problem is that the gold is lying with the department from, I believe, 25 years or something. We had given a notice to them to come pay the fine amount and collect the gold in 2005. They have now come. Now the department is finding it difficult whether it has gone to the mint or something. So they want some time to search where it has gone. 3 weeks time may be given, my lord, they will search. Because the petitioner has.
On date.
13 August.
13th.
I'll try.
56. Srihari.
My lord, in this matter, my lord, I have to complete my pleadings. After 3 weeks, it may be taken up.
Lordship, interim prayer has to be considered. Lordship may have it next week. There's no interim on.
There is urgency in this matter.
This is just, my lord, their application to condone the delay in filing returns has been
Rejected.
rejected. That's all, my lord. Now I have instructions that we may have to file this thing, objections, my lord. I'm awaiting instructions. After 2 weeks, it may be called out.
List after 2 weeks.
57. Harish.
My lord, some urgency in this matter for interim orders if you could add tomorrow, my lords.
Who appears?
State, my lord.
State.
57.
Tomorrow. Land Council Shamant Naik accepts notice for the respondents. This is the matter tomorrow.
58 urgent. 59. 59.
My lord, 59. I require some time, my lord.
At request of the respondents. Relist the matter.
After 2 weeks, my lord. I'll take instructions in this.
After 2 weeks.
60.
My lord, GST appellate tribunal not constituted. We've already paid 10% after the appellate order, my lord.
You have already paid?
We've already paid 10% after
That
the
is at the
order.
appellate stage. Again, they'll have to pay another 10%.
We've already paid that.
20%.
20% I've paid.
60.
Sure.
Review deposit.
File code.
Where is the deposit? Thanks to that.
Page 192.
to verify this, my lord. Should I have it tomorrow?
Tomorrow.
Great.
Yes. Shaman Naik accepts notice for the respondents.
Great.
We'll list the matter tomorrow. Yes.
61, 62 urgent, 63.
This is Indian Oil Corporation, my lords had argued this case. The
Yes.
Delhi High Court, same matter is covered.
Who appears in that?
My own case, I think, Mr. Jeevan.
Jeevan. 63.
Any day, my lord, convenient.
My own case, my lord, the Delhi High Court has granted the refund. Lordships would remember, I had argued this matter where the inverted duty structure. In my own case in Delhi High Court, I had said that refund is grantable considering section 54 of the CGST Act and the reverse, the inverted duty structure that is there. So all other jurisdictions, my lords, have also granted refund. If your lordship sees the previous two orders which your lordships have passed, you'll see that the refunds have already been granted in other jurisdictions except Karnataka.
Yes.
Week, your lordship. Next week or week after next, any day, convenient.
You take a date.
Week after next, my lord.
Could be kept on the disposal list if any such list is contemplated by
Yes,
your
yes.
lordships,
Yes.
so that this matter could be disposed.
Which date? Which date you say?
6, 7, 13, 12.
What? My lord, 13th August.
It'd be the first
6
week,
or
and
7,
6th or 7th, we can dispose it up. Anyway, 6th I'm here, man. 6th is, 6th is
My lord,
what day?
13th will be Tuesday.
List the matter on 13th in the orders list.
Please.
In light of submission of learned senior counsel appearing for the petitioners, that in the case of the very same SSC, High Court of Delhi in Indian Oil Corporation was Commissioner of Central Goods and Services Tax, reported in 2023, 13 Syntax 228 Delhi, has upheld the refund. Yes.
64.
64, my lord,
On
taken
13th,
up
my
next
lord.
week.
I'm appearing for the petitioner, Your Lord.
13th.
Your Lordship, there's only very short compass, Your Lordship. The hearing was not granted and the order was passed. Only two hearings were granted. The provisions under section 75(5) state that at least 3 hearings have to be granted, but he was in the process of collating the document. And
Yes.
also there was discrepancy in the
Next week, my lord, there, section 80 had asked for installments. Whether an installment can be given or not. If he's going to
Relist the matter on date
any date,
7th.
great.
65, 66 urgent, 67.
Right.
Shivkumar.
My lord, this petitioner is a government of Karnataka undertaking. There is an order passed by the adjudicating officer. Actually, my appeal is pending before the appellate authority. Meanwhile, without waiting for the appellate authority's order, the adjudication order has been given. I have to pay one.
No, there was any stay of.
We have sought interim order.
Was there a stay in the appeal?
The stay was not granted. We had sought a stay
But
before
that
the appellate
matter, my
authority.
lord, SESC is a party, state department dispute. It said, my lord, we'll refer it to the additional chief secretary to resolve this dispute. I had placed, my lord, on record on that dispute resolution policy, my lord, where we'd have to refer it to the additional chief secretary of the energy department
passed
as
some-
well as the.
Some
Yes, my lord.
observation has been made.
No observation has been made, my lord. They were supposed to decide whether they wanted to mediate or not.
No, my lord.
Accordingly, we had to.
The GST matter would not come under that notification. Last time my friend had given that notification.
No, GST also is involved in that. All. Lordship may have it next Wednesday, my lord.
No, but where is the bar that these matters can't be resolved? We have passed an order.
Yes, Lord.
Stating that after following the judgment of the Apex Court.
Yes.
In that petroleum, and stating that all disputes between state entities must be resolved through a process.
Yes.
That's pursuant to a order of the Apex Court. We'll have it tomorrow.
Yes, ma'am.
Tomorrow.
Great.
Release the matter, I don't think. Tomorrow. This, there's a reference, Dr. S. Dwarkinath versus University of Agriculture Sciences.
68.
I'll place it tomorrow.
Yes.
68 Partha.
Lordship, this matter may be taken tomorrow, your Lordship. It's a covered matter. Reasonable opportunity was not given to me before passing the order. And even the
Just 1 minute,
order
just
also.
It can be sent back. It can be sent back.
Yes,
tomorrow,
your Lordship.
tomorrow.
Tomorrow can be taken, your Lordship.
69. 69.
Writ of mandamus for refund, that's all.
Hmm.
I'll leave it to your lordship, I mean, subject to your lordship's convenience.
It can be disposed of tomorrow.
Tomorrow.
Great.
70. 70.
Goods and Service Tax Act, my lord. Without passing speaking order, they have passed only summary order.
Take notice, my lord, it may be taken up next week for consideration of interim prayer.
Learned Council
Look into
Arvind Chavan accepts notice for the respondents. Consideration of interim prayers kept open.
Next Wednesday,
This is the matter on
31st or 30th.
31st.
Mainly on caption order.
71. 71.
My lords, appearing for the petitioners, my lord.
For the respondent in this matter.
Yes.
This is pertaining to the inquiry before the registrar. This time, all the documents I have filed, we have retained all the documents from the banks also. I filed it along with an application seeking permission to produce before the registrar to mark in my inquiry. So that is IA number 7.
That order has to be passed.
Yes.
Yes. We'll allow the IA.
I have served the copy also.
Who's?
71.
My lords, for the petitioners, my lord.
We'll allow that IA, I'm saying.
Very well, my lords, very well, my lord.
IA 7 of 24 has been filed for seeking permission of production of additional documents filed by the respondent. Taking note of the list of documents and the reasons assigned in the affidavit in support of the application. Case is made out for permitting the said documents to come on record. Accordingly, IA is allowed and documents are taken on record. Now it has to go back.
Go back for further
Matter
inquiry.
relegated for further inquiry.
72.
Date
My
may
lords, a
be-
short date may be given.
Date may be
Date.
fixed before the registrar.
5th.
Obliged. Your Honor.
72.
My lords, kindly 2 weeks time may be
Just
granted.
after 2 weeks at request.
73.
How much?
At 73, I may have to complete pleadings.
Just after 2 weeks.
74.
List next week.
75.
My lord,
6th of August.
in
It is already
75,
6th
my
of
lord,
August.
pleadings have to be completed, my lord. May be taken up on 13th, my lord. One other matter which was at serial number 19, even that may be taken up on 13th. At least by that time we'll complete the pleadings.
13th.
13th.
75 and
Sir, 19.
19.
19.
19.
As well as 20, my lord.
19 and
That's what I
20.
made a submission in the morning, in another matter.
19, 20 and 75. 19, 20 and 75. 19, 20 and 75. List on?
See, there are rules which they have challenged, my lords, maybe little more time, because it is not an export. They have acted as intermediary according to the department, the order. So they have challenged a few rules of the provisions also, CGST Act, GST.
The matters are similar to what is there in 76, my lord. Senior Mr. Shivadas argued this matter.
Let us see. So when do you want it?
Maybe 3 weeks, after 3 weeks, some date maybe.
In order.
20th.
August, obliged.
Interim orders to be extended.
Interim orders in operation are extended.
19,
till
20
the
as well as in 70.
Next date. In 19, 20 and 75.
75.
That's a check, madam.
78. Pradeep Kumar. 78.
My lords, I appear for the petitioner. Lordship, as directed by my lord last time, Mr. Sandipani would hand over the papers, please. I have prepared the list of dates and events So Sandeep, please. Go. Dates and events I have prepared, my lords. My lords wanted to know whether my.
Just one, yes, just 1 minute.
Please, my lord.
Manjuna. Yes.
My lords, the list of dates and events, I would just run through it for my lord's benefit. 29th, first they went to the place which is under redevelopment. They came to my office at Masjid Bandar in Mumbai at 9:30 a.m. And at 2:30 p.m. in the noon, they took away all my mobile phones and also CPU and hard disk. So I had no access to anybody, including the bank also. And Lordship would recover. All throughout they continued. They stayed there at night also. On 30th July, 30 July, serial number 5, my lord. At night at 12:30, they decided to sleep in the office. They slept in my office. And apart from everything, my lord, I also complained in the petition about inhuman treatment given to me. Then 30th, again at 11:30, few more officers came. One of the officers physically removed me from my chair where I was sitting in my office. He says, now I am the person in charge. 30th, same day evening, he started typing without showing me the statement, which was ultimately, Lordship would find, on serial number 8. Tired at 11:30, I agreed that all right, I will manage and pay 1 crore next day, because by that time, my lord, RTGS was also not possible. Those were the time where around 10 or 12, the RTGS would close. I think 10 o'clock. 12:30 at night, my statement was taken. It was signed by the 2 witnesses who were the drivers of the officers. I have stated there, my lord. Part of the show cause notice, it is there. I will come to the show cause notice also. Same time, they issued me the summons also to come to Bangalore on 2nd August, which I requested that I'm too exhausted. I will not be able to travel on the same day. So they also said that you come on 3rd. But next day, my lord, 2nd August, they again called me that you must come anyhow. Don't come late and all those things. And I attended. 31st July, what happened at 12:30 a.m. As soon as possible, I managed and paid 1 crore by RTGS. Well, this is very important because it could not have been possible at the middle of the night on the earlier date. On 3rd, again, I went there in the morning.
I couldn't hear you for some time.
I'm sorry, my lord, I'm very sorry. I was on serial number 8, my lord.
Yes.
My lords, please. Late at night, statement was coercively signed. Pancharama signed, whereas my lords would call it Mahazar, my lord. Wherein witnesses were not 2 people of good standing of the locality, but they were the 2 drivers. Then again, same time, they served me the summons to attend in Bengaluru. We were till then in Mumbai. On 2nd August, I informed them that since last 3 days, it has taken toll on my health also, and I'm exhausted, and I should be allowed to attend after a few days, which initially they agreed, but they constantly called me on 2nd and directed me to anyhow attend on 3rd. So, same day afternoon, my lord, 31/7, I made the payment of 1 crore by RTGS because that was the assurance taken from me. Otherwise, they would have arrested me there and then. That was, my lord, all the actions are under the threat of arrest, which I have stated in the affidavit as also in the petition. Now, 3rd August, my lord, I went in the morning. I was kept waiting till afternoon. While all the phones and contact details was unavailable since 30th July 21 due to seizure by the authority, the officers directly talked to the debtors of the petitioners. This is part of my petition on page 54, my lord. 67, sorry. Directly spoke to the debtors. Respondent made them deposit the payment in my account. Subsequently, after confirming the payment, petitioner's seized phone were returned and it was informed to make him payment of 1.5 crores by e-challan since they will not be able to access the OTP on phone. So they would now be able to, access the OTP on phone. So my lord, I was sitting at Bangalore. I was asked to file e-challan. I had to instruct my office to do all the formalities. While I was before the authorities, I instructed my office, please make the payment, because I was told until I make the payment, I will not be able to leave the place also. The petitioner was also under the constant threat of arrest, and the payment was condition precedent to allow him to leave the Bangalore office. The petitioner's CA, who was also traveling, asked to request the officer to allow under protest letters. This is very important, which they refused. Because I wanted to make payment under protest, which they refused. Serial number 12, my lord, it should be DRC 03, not 1, my lord. DRC 03 for both the payments, that is 31.7 and 3.8, are attached. I have attached herewith. Petitioner was strictly forced to make payment under 74.5. On 10th August, now my lord, see, this is after exactly 7 days. Petitioner was mentally drained, physically exhausted due to 2-day detention in his office, subsequent rush to Bangalore. After coming back, he took a few days to mentally and physically recover and finding legal help, where he was directed to note down the entire details in an affidavit and file an interim retraction affidavit till the statement is received. I was not given copy of my statement. My lord, one must, last time my friend says I filed after 15 days. It is filed within 7 days. These were peak second phase of the COVID, my lord. In that also, I went to Bangalore also, I came back, I filed the retraction statement. They were not willing to take any statement. So 16th September, within 1 month, my lord, I immediately approached my lords by way of writ. On 30th September, my lords have granted protection from coercive recovery and we agreed to cooperate with the investigation. 1/12/22, after almost 15 months, show cause notice is issued by DGGI, transfer to nodal officer Thane. Petitioner never called again. After attendance was never called again. Actually, not given. I was never called again by Bangalore officer. After my last attendance on 3rd August, the petitioner has complied with each and every detail in the show cause notice and attending. Now, my lord, the first argument of my learned friend was that your retraction is delayed, which is wrong, because within 7 days, lordship would find that statement on page 149, my affidavit before the notary, which is filed. And since nobody would accept it, I had no alternative. Lordship, on annexure H to the petition is my affidavit. We have read it already. May I go to the other
Page
149 of the petition, lordship would find my affidavit, which ends on page 157. Lordship would find the date there. 10th August 21. And my lord, my whole problem was I was dazed. My profit is less than 50 lakhs a year, losing 2.5 crore. I would not know what to do next. That was the whole issue. I had no knowledge. And of course, there was a geographical issue also. COVID going on with all the restrictions. Even then, my lord, filing a writ petition also was a challenge for me within a month's time because of the distance, because of the COVID also. Then lordships, I have also, as my lords had directed last time,
Yes.
I have few more papers. Now, what is show cause notice issued to me? Mr. Sandeepani, can you please hand over show cause notice and other papers? My reply to show cause. These are forwarded to my lords under the signature of my client because these are all factual aspect. Lordship would find on the next page, even on 19th July, I am complying, 2024. I have complied with the details which they are still asking me. The investigation is, the show cause notice compliance is still going on.
The show cause
Closing
notice,
stock- My
show
lord,
cause notice is dated 30/11/22.
my lord, yes,
Now the subject matter of the show cause notice
yes, my lord.
includes the amount that you have paid or excludes?
My lord, includes, may I point out page 24 of the show cause notice may be seen, my lords.
Page?
Page 24 of the show cause notice, my lords. Internal page 24, my lords. Lordship, may I read 16(1)? An amount of 4 crore 57 lakhs availed by.
Just 1 minute, just 1 minute.
My lord, please.
You are at page 20.
24,
my lords.
of the show cause notice, my lord.
Lordships may kindly see 22 also. Better, my lord, to start from 22.
That's a conclusion.
Payment made by Kesar Color Chem Industries during the course of investigation. Lordships may.
Just
Yes, yes. That is true, but it is not excluded. That's what I am showing. These are the
Contraventions.
Then, my lords, come to my lord, the
My
last
lord,
page, my
page
lord,
16.
24, as my learned friend has.
Paragraph 16 on page 24.
Para 16.
Yes.
Now, my lords may recall last time my lord says ascertainment and that amount should not be issued show cause notice. For the, with that reference, I am pointing out this, my lord. 16(1), amount of 4.71 availed by Kesar for the fake invoice of Raj should not be considered as ineligible, fraudulent, etc., etc. Input tax credit amounting to so much availed between November 20 to July 21 without receipt of goods should not be demanded and recovered. Amount of 2.50 crores paid should not be appropriate against the demand mentioned. It is included in the total demand. It's not that though no demand is raised for 2.50.
No, the one legal consequence,
My lord.
suppose there's a self-ascertainment.
Yes.
Under 75, then no further demand.
Then,
Please.
my lord, can, my lord, further, my lord, he reduces that. He takes note of that payment made.
No, but
He appropriates to that.
no, correct. But under that section, it should be dropped. Just have a look. Just go to 75. 75, isn't it?
74, 5.
70?
4, subsection 5.
74(5).
No, see, just see 74(5).
My lords.
Now, once under 74(5), there is self-ascertainment. Under 75(6), the proper officers on receipt of such information shall not serve any notice, and the proceedings comes to an end.
My lord, 7, your lordship speak. Where the proper officer is of the opinion that the amount paid under subsection 5 falls short of the amount actually payable, he shall proceed to issue the notice as provided for in subsection 1 in respect of such amount which falls short of the amount actually payable.
Correct. That is insofar as the self-ascertainment is concerned. So suppose under the self-ascertainment, he makes one self-ascertainment. In that calculation of his, if there's a shortfall, only then you can go to 75(7).
Yes.
So let's assume now there is self-ascertainment as
To
per
the extent of 2 crore 50 lakhs, my lord.
then it terminates then itself. Insofar as
That amount is itself, my lord, there is no this thing. My lord, for remaining, my lord, he says 4 out of 4 crore 57 lakhs, 2 crore has already been paid. It will be appropriated to the total demand. For remaining, my lord, this is a show cause notice to be considered, if it is to be read as a whole, my lord, it is to be considered as, my lord, a demand in respect of the remaining amount only, my lord, because he has discussed it. He has, my lord, he says that, Lordship may kindly see, my lord, on page number 22.
Lordship, may I refer to Rule 142, where if such acceptance, 142, if I pay under DRC 3, they have to issue me DRC 04, 142, Rule 142. May I read, my lord?
Lordship, may I just, my lord, 174.5. I just read once again.
Yes, just one minute. Just we'll come back.
Yes.
Rule 140.
142.
142, my lords.
Yes.
Notice an order for demand of amounts payable under the text. Now I'm on 1A, which is not, I'm on section 2, subsection 2, 142.2.
Yes.
Where before the service of notice or statement, person chargeable makes payment of tax and interest in accordance with provisions of 73.5, or as the case may be 74.5, or where any person makes payment of tax, interest and penalty on any other amount due in accordance with the provision, whether on his own ascertainment or communicated by the proper officer under 1A, he shall inform the proper officer of such payment in DRC 03. And the proper officer shall issue acknowledgement accepting the payment made in form DRC 04. Then, my lord, subsequently, he has to issue DRC 05 also in terms of subsection 3. And my lords, all this, my friend is arguing about 74.5 and ascertainment. Where is the ascertainment? Where is the proof of ascertainment in any case?
Now this, under Rule 142, these DRC forms were not issued.
Not at all, my lord. DRC 3 I have filed because that's my challan. I have annexed with the today's compilation also. DRC 4 is not issued. There is no self-ascertainment, my lord. And my lord, let me point out the second payments on 3rd August, they were under coercion and they have recovered from my debtors. My phones were with them. I could not have called them. It is their phone call record. If you call for, we will be able to show that it is they who have called them and compulsory made them and made me sit there and there until I make the payment. They are saying in the reply that you change the tickets because I had to. I was told unless I make the payment, I cannot leave. I have slept at the airport at night, my lord.
Now after DRC 03, there were no DRC, subsequent DRCs
No,
issued.
no, my lords, nothing. Straight away, there came, as I have stated in my chronology of events, I received the first show cause notice on 1st December 22. There was no DRC 04. And my lord, one more issue, which it's a very minor issue. But this section says you have to pay tax and interest. If I was ascertaining myself, I would have paid tax and interest both. I was forced to make the amount as tax. And I paid tax only. This is what the force was made to me under the threat of arrest at all the level. Because they were estimating 4.88 crore, some evasion or whatever, non-availability of ITC. And my lord, it is futile to argue that this was ascertainment. I would not have come to my lords within a month's time.
Yes, yes.
My lord. 74.5, lordship may once again.
No, but yes, prima facie, if you have to save your show cause notice, then you have to give up self-ascertainment.
No, lordship may kindly see the show cause notice for a moment.
No, correct. But suppose
the authority has not denied the, my lord, this payment of 2.5 crores and adjustment of the same towards the final liability.
No, that payment, if it is to be made prior to adjudication, could have been appropriated only if it is self-ascertained. as contended by you. Let's assume that,
Right.
so because of your contention of self-ascertainment, now finally you have gone on to the show cause notice means process of adjudication is still on.
Process of
my lord.
adjudication is still on in, my lord, as far as the remaining amount is concerned.
No.
Out of 4 crores, 75 lakhs,
But look at
57
the,
lakhs.
correct, but the
I'm
show cause,
contesting
That has to be
2.5
determined, my
crores.
lord.
but the show cause notice,
My lord, show cause notice says, this is the total amount of, my lord, which are liable to be recovered from him. Out of that, my lord, he has paid the, my lord, voluntarily 2.5 crores. My lord, this 2.5 crores is liable to be appropriate towards the final demand. But the total default, my lord, he mentions.
no, but,
My lord,
Yeah,
while
but if
issuing
there
a show
is-
cause notice, your lordship mechanism, my lord, quantification is one aspect. How much is to be, my lord, that we, this thing, considering the prior payments. But the entire, my lord, this thing is total default after the investigation is, my lord, this is the total amount out of which this is the voluntary payment. So the remaining has to be appropriated. That is the why it should not be appropriated. That is the show cause. This is only a show cause notice.
no, but can amounts be paid before show cause notice?
Whether
Amount
they
can
have
be paid
power
before.
under 67, my lord,
But if,
to recover.
if they claim that the amount is paid under duress,
Please.
then they are entitled for refund of that. Show cause is an independent adjudication.
Precisely, my lords.
You can't withhold it once they say it is involuntary. Let's assume,
My
even
lord,
if,
they, my lord, in every case, my lord, they.
no, but that is the
Actually,
position.
they say
My
that.
lord,
because
bundle
if your lordship's
technology, I
can see
have
the
pointed
history,
out 5 judgments.
In most of the cases, and I'll just, my lord, I take lordship's, my lord, tomorrow or day after lordship may have it, my lord, I'll just take to what
My
is
lord,
this.
how many
list of
hearings?
dates and events.
Tomorrow 2:30 I'll have it. Well.
Please, please.
My lord, please.
No, but this is the same position we took in the previous one.
No, my lord, that
My
bundle
lord,
technology,
bundle
my lord,
technology. I have pointed out all the judgments. I would point out one
Okay.
more latest
kind
judgment
of
of Delhi.
far-fetched, my lord, allegations.
No, allegations.
Which have,
No, we'll discount the allegations.
No, my lord, they don't want to do us anything. That is the tone and tenor of the argument.
No, we'll discount the allegations.
Search and
I'm
seizure,
not
my
on
lord,
merit,
always
my-
leads to a temporary suspension of certain
Whether
rights.
you
and
can-
not there. Now
My
they
lord.
cannot say that they have seized my mobile, they have seized CPU, and thereby they committed an atrocity like this. My lord, we have seized it. We have retrieved
I
the
never
data
said
in
that.
presence and returned all the gadgets to him.
No, that apart. No, that apart, but once amount is paid, which they claim is paid under duress, until adjudication is complete, you can't withhold.
Precisely,
assume-
my lord, under
let's assume-
67 and
let's
70,
assume-
they have no power.
Now, let's assume that they make some payment and then they retract saying it is under, it's involuntary. There ends it. Then that amount then has to go back to them. Adjudication is,
My lord, retraction is a bona fide or not, my lord,
no, that we can't.
My lord, their,
That is to be decided on merit.
Once
Let
they
us see, my
say,
lord. I can prove today
there
also.
ends the matter. Matter is open for
my lord,
adjudication.
retraction is a bona fide or not, my lord, that is again, my lord, a
My lord,
disputed.
retraction by a.
You can't hold their amount. You are within your powers to pass appropriate order and enforce the demand consequent to adjudication. But till then you can't withhold. It would be against 265.
My lords, I agree. And under 67, my lord, they have no power to recover any
That
money.
is the legal
Same with
position.
70 summons. Where are
This
the
is, my
powers?
lord, no, I will, because the way the allegations are made,
Discount
the
it
way, my lord,
for,
the
we'll discount it for.
petition, the pleadings are, my lord,
No, we'll discount the
that we
allegations.
should not do anything.
No, we'll discount the allegations for a minute. But then amount paid, which they subsequently take a stand, it's involuntarily paid, that you can't withhold. No doubt you're entitled to complete adjudication, raise demand and recover. But anything pre-adjudication, you can't withhold. That is the legal position.
No, not part of
230, you take your stand on that.
My lord, if it is forcibly recovered without determination. Well, my lord, their contention is, my lord, now, my lord, when the amounts were paid through DRC 03.
Correct, but you have not followed up with DRC 4, 5 or 6.
That's my lord, a procedural, my lord, I would say, my lord.
There
not a
ends,
substantive,
correct. No, suppose it was self-ascertainment and DRC 3 was issued. Then you follow it up with 4, 5 and
4,
6.
5, my lord.
Then the claim there ends.
Precise.
Technically,
To that extent, my lord, it goes, if it is anything in excess, my lord, I have to issue, my lord, to continue with the proceedings.
yeah, but here now
Can't be, my lord, like.
correct. So what I'm saying you have to keep in mind. If you say self-ascertainment, show cause notice is defective. If you give up self-ascertainment, your show cause notice may continue. But you can't have a part show cause notice because of 75(6) and continue the remaining. It will be faulty.
My lords.
Let's assume
Lands.
that portion he has paid, and let's assume he has filed DRC 3. Let's assume that you filed 4, 5 and 6. The show cause notice, if at all you issue, is for some
Remaining amount,
remaining adjudication.
remaining amount.
Correct. But you can't split it up
My
now.
lord, the thing is, my lord, adjudication cannot be, my lord, like, my lord, that has to encompass within itself, my lord, all allegations, including the, my lord, total amount. Then, my lord, will give up the, my lord, the amount which has already been paid.
Correct.
See,
But
that's what the show cause notice does here.
no, but 75(6)
I can't bifurcate, my lord, because he has paid this.
No, but
I
75,
will exclude this part of an allegation from the show cause notice.
75(6)
It's
says,
only for an ultimate quantification, my lord.
Absolutely, my
75(6)
lord.
says he
Long
stands
arguments are
discharged.
going on.
Because my show cause notice loses the link. If I say that, my lord, he paid this much, so I, my lord, ignore this, or I will, show cause notice will not be, allegations will not be a part of the show cause notice as far as this amount is concerned.
My lord, these are all
Allegations
wrong
there,
explanations
the entire
going by my
comprehensive
management.
investigation. So, my lord, he says that total amount was liable to be recorded so and so. Out of that,
There
voluntary
should be
payment
no
was
show
made.
cause notice thereafter, my lord.
No, in the
Why
show cause
also
notice,
part of it?
on a reading of your show cause notice, whether you have taken the stand of 74(5)
My lord, that's what, my lord, page number 22, lord, just may for a moment.
of the show cause notice.
Yeah, they can, that's what I brought it in my lord's notice.
My lord, these are all the merits I can comply with today also, my lord, before my lords.
13.1.
I was,
13.1,
my lord, paragraph.
yeah, he writes voluntary payments that they are bound to write. That is why I am before my lords.
No, but you stop at that. You don't go to self-ascertainment.
It says, my lord, it's voluntary paid.
Correct. So now, once they retract that, and if it does not amount to self-ascertainment, you will have to refund that. Your show cause notice will continue with adjudication. Let's assume that the show cause notice for the entirety, you can continue, but they will have to refund this amount. You can't withhold it. No doubt you can continue in a show cause notice for the entirety of what you have stated. So without entering into that, we'll only stick to payment made, which you are saying voluntary, and they are reselling. Whether that amount can be retained with you, no.
Precisely, my lords.
Look at and make your reply tomorrow.
Please.
Release
No.
tomorrow at 2:30.
Please, my lords.
Wait for minutes.
No, thank you.